Indigenous people, and then a history session, a very substantial history session, and a criminal law session before the conference dinner for those of you who've subscribed to that. Technically or technologically, we should have people online listening as well, and more particularly, we should have some in the Supreme Court in Hobart, who hopefully will be online now or soon. My job just now is to introduce Uncle Michael West, who is to welcome us to country. Michael West is a member and cultural representative of the Metropolitan Local Aboriginal Land Council, the traditional custodians of the land, air, water and culture within their boundaries. He's an Aboriginal man from the Gomeroi Nation, born and raised in Sydney, a member of the Stolen Generations. He is on the board of New South Wales Indigenous Chamber of Commerce, a national executive member of the National Sorry Day Committee, and is a delegate of the National Congress of Australia's First Peoples. He's had a variety of previous roles as director, the New South Wales Indigenous Chamber of Commerce, as I've mentioned, a director of the Australian Communications Consumer Action Network, the Aboriginal and Torres Strait Islander Advisory Group, Australian Curriculum Assessment Reporting Authority, and he's also cultural advisor to TEDx Sydney. He's well known and respected by those of you who have been to a formal legal ceremony in Sydney over the past years, and it's particularly fitting that he welcome us to the first session under the chair of Justice Julie Ward. The first session, as I've mentioned, being courts, legal systems and the Indigenous people. So please welcome us to country. Thank you.
Thank you. Thank you. I'd like to say Bojadi Gamarua Gadigal Yora, and good day and welcome to Gadigal and Yora country here. And kia ora to our friends from New Zealand, Te Aroa, the long white cloud. And we're just having a bit of a yarn about similar experiences and not so similar experiences through our journey here. And obviously where we are here is a place, sounds like the connection's been made, and we all need a bit of a laugh, I think, in the times we're going through. When you think about the times we're going through, they're very tumultuous times in the world, aren't they? Yes. We have a raging war in Europe for the first time in about 70 years, started by someone who's a war criminal, who, in the context we're just talking out there, they a war criminal for taking children away from Ukraine and taking them to Russia to indoctrinate them in who knows what, starting a war, claiming that the people that he's fighting are GLBTIQA plus Nazis, and it doesn't quite make sense, does it? No, the two things going together. And also around the world, we have, in another country, we have a president's been indicted 4 times. So the law is being played out across the world, isn't it, when you think about it? And also, when you think about it too, here in Australia, it has been a conversation that we're having on multiple fronts like voice, treaty and truth. And we need to have these tough conversations or yarns, and they have to be truthful. They need to be based on fact. And it's a combination, when you think about it, making choices. We need to make informed choices, and it needs to be a combination between one's heart and one's mind, I think, and also drawing on who you are, your identity and your cultural identity. And, you know, we've got a long way to go. One of the organisations you mentioned I was part of, a National Congress, that was an organisation that was set up. That was one of the organisations that went by the wayside, one might say, apart from ATSIC and other organisations, that we really, I guess, need to be at the forefront when policies and processes are made if we're really going to change this country and be so so we can have better outcomes for our communities and our people when you think about it. Even today, like an Aboriginal child just born up the road up here in one of our hospitals is around 9-10 years difference life expectancy and around 14 in regional remote, which isn't right in a very rich country that we have, one of the richest first world countries, and the opportunities should be granted to everyone. No matter what postcode you were born in, no matter the colour of your skin, the shape of your eyes, the gender you identify, you should be able to fulfil your dreams and aspirations in this country. And I was just talking to someone from the UK last night, and they were just surprised how big Australia is in landmass compared to the UK. They were talking to their friends. It was an interesting conversation. They was talking to friends, and they're saying, we're from one place to another in Australia. You can just drive down the road where it's like here. No, I think it's like 3% the size of the landmass of the UK is of Australia. So when you're talking, I'm going down the road to visit someone, it could be going down 200 to 300 miles down the road. And it's quite vast, our wonderful brown sunburnt land that we have. But we do need to take a moment's silence to pay respects to ancestors, and we need to pay respects to all Aboriginal and Torres Strait Islander traditional owners, elders and custodians of the past and present for looking after wonderful land that we have and spirit of country. And we need to pay respects to Mother Earth. Mother Earth provides us with everything. All our buildings, all our food, all our clothes, everything comes from Mother Earth, and we need to respect her. It's been very sad the last couple of weeks. I was thinking about this. Did anybody see about the penguins? What happened to them? Yes, very sad. We've lost a generation of King Emperor penguins, chicks, because of climate change. The ice didn't last as long as it usually did, and what's happened is all the chicks have now fallen in the water without their feathers that can keep them warm or survive the conditions they're in. So they basically would have been drowning or would have been eaten by their predators. So it's very sad. Also with Mother Earth, you can see the implications all around us every day with the wonderful sacred ibis. And everybody knows the sacred ibis. Yes, it is sacred. Please don't call me a bin chicken. It's like what he's saying. Because think about this, the sacred ibis, there's a whole story of who they are with underneath, well, they've got red underneath, but I'll let you research that. But what I was going to say, the only reason they are in our cities and going through our bins is because we haven't respected Mother Earth. We've had floods, we've had droughts, we've had fires. So now they've moved to the city to survive. So that's why we need to care for Mother. And it's important we remember those we lost in this pandemic we're going through. Yes, we're still going through a pandemic, losing about 100 Australians a week. And we need to remember that they're not just a number, they're part of families, they're part of communities, they have their own dreams, their own names. So we need to remember every week we are losing our fellow Australians to this pandemic. And hopefully that when we come out the other side, we can celebrate with our I'm hoping for a parade just down the road here in George Street for our health workers and those in logistics who have got us through this. I think it's important to recognise them because it has been a very tumultuous. We had the whole world locked down at one stage, didn't we? And it was quite scary for everyone. People were afraid to go out of their homes. So if we just have a moment's silence to pay respects to them and to pay respects to the ancestors and pay respects to Mother Earth and to reflect our journey right here, right now and how the law impacts on all of us every day. We have three beautiful waterways here in Sydney, the Hawkesbury, Nepean and Georges, which are the aquatic boundaries of our nation. I'd also like to recognise the land, obviously, down in Tasmania to wherever we're streaming, I think is important, and for people to learn the rich history and the culture and the sites where they are. Because as Australians, we all have a responsibility to look after our culture and our sites, to protect them for humanity itself. We have those Brewarrina fish traps that are 40,000 years old here in New South Wales, the oldest human construction in the world known today. On behalf of Metropolitan Local Aboriginal Land Council, we welcome all our brothers and sisters here. We welcome our Aboriginal and Torres Strait Islander brothers and sisters from the country, the clan, the tribe and the nation you come from. New Zealand brothers and sisters, we welcome you from the country you come from and the rich history that you have. First Nations there, the Māori. And we welcome all of you as our brothers and sisters from this one big tribe we belong to, humanity. We warmly welcome you from your community, your family, your neighbourhood, ultimately country you come from. We share this little blue sphere we need to care for called Mother Earth, who looks after us. So on behalf of elders and members, welcome here. Enjoy your time here. Have vigorous conversations. I think it's important, honest conversations. And always was, always will be Aboriginal land never ceded. Let's create a great country. We can do it. It will take those tough conversations, but anything worthwhile is not always easily achieved. So I'll leave you with those thoughts. Thank you.
So I'll now ask Justice Julie Ward and the panelists for the next session to move down here. So what I suggest is that when you're speaking, maybe speak from the lectern, and then when we get to questions and answers, the two microphones on each end. If you want to answer sitting, if you prefer to answer standing, then probably the lectern is the best place to do it. No.
Thank you, Uncle Michael, for your instructive and inspirational words. I too acknowledge the traditional custodians of the land on which we meet here today, the Gadigal of the Eora Nation. I pay my respects to their elders, past and present, and to all Aboriginal and Indigenous and First Nations people here today, either present in the courtroom or on the live stream. It is important that we acknowledge the long-standing and deep connection of our Indigenous and First Nations peoples to their country and to our country. And in that regard, it is fitting, I think, that we've had such an inspirational welcome to country this morning. Under the leadership of Chief Justice Spiegelman, there was the first welcome to country, as he reminded me last night, on the occasion of this court's 175th ceremonial sitting. And so it's fitting that as we approach the 200th, we are continuing in that tradition that was introduced by His Honour. I have the pleasure of introducing our speakers this morning. Unfortunately, Professor Megan Davis can't be here with us today, but I'm sure that we'll have plenty to fill up the time from the speakers that we do have, each of whom will speak for roughly 20 minutes, and then there'll be time for questions either from the audience here or via live stream in Tasmania, and I'll come to that in a moment. Our first speaker is Professor Val Napoleon. She is the Law Foundation Chair of Indigenous Justice and Governance at the University of Victoria, British Columbia in Canada. Her current research is focused on Indigenous legal traditions, including legal theories, law and precedent, and legal institutions, Indigenous feminism, citizenship, self-determination, and governance. Professor Napoleon has worked as a community activist and consultant in Northwest British Columbia for over 25 years. She graduated with a law degree from the University of Victoria in 2001, was called to the British Columbia Bar in 2002 and was awarded a PhD from the University of Victoria in 2009 with a dissertation on Gitsen law and legal theory, and she was awarded the Governor-General's Gold Medal for the best dissertation of that year. Professor Napoleon.
Thank you for that introduction, and thank you for the welcome to these lands. And I'm delighted to be here. It's the questions raised by this gathering are really important and have caused me to think more deeply about my own work. And so I'm always grateful when that kind of learning happens for me as well. So there are 3 parts to my short talk today, and I'm just going to sketch these out because, as was pointed out earlier today, I haven't actually submitted this as a paper. And so the first part is to look at law from a macro level, and I want to provide this as a possible first step to engaging productively across legal orders. So thinking about what does that mean at a macro level. Secondly, I'll turn to what might we think about when we consider micro levels of engaging across legal orders. And I'm going to set out some requirements for looking at legal orders other than our own. And third, and this will be pending time, is I'm going to provide some examples of law from several different Indigenous legal orders. So to just set the stage in a tiny way, Canada is a big country, as is Australia. And we have, across the lands, we have about 20 linguistic groups. Those linguistic groups are divided into about 60 societies. Some people use the language of nations. And each of those societies has a legal order. And so, for example, the smaller Tsimshian linguistic group has 3 societies within it. Each of those societies has lands, a legal order, language which is distinct to those people, and numbers of small communities. An example of a larger legal order which extends from the far north down into the United States, so the Dene peoples down to the Apache peoples, there has many societies that comprise the overarching linguistic group, and many communities within each society, and lands that the legal order extends out over. So there's, it's helpful to think about that diversity of language, that diversity of legal history. The other tiny fact here that's important when thinking about future work is that there's a 400-year history difference in the East Coast and the West Coast insofar as colonization and settlers coming to Canada. So historically, these legal orders were non-state. Law and other authorities were distributed through decentralized institutions, various forms of governance, various forms of kinship units. Yesterday, Chief Justice Susan Kiefel quoted Jeremy Bentham, who, when speaking about Australia and observing the legal practices in this country, he asked, how does one account for the presumption of legal power? And that's such an important question, and one that touches on different aspects of what I'm going to raise here in this talk. So the macro level, what am I talking about here? So I want to introduce this concept of legalities, which require us to think about the conditions that create and comprise law. In other words, what makes law law? When we have our community discussions with Indigenous peoples and doing the work that we're engaged in, this is one of the questions that we have as part of the work of restating, articulating law from those different legal perspectives. So legal theorist Lon Fuller set out 8 legalities that he argued were necessary for law to be law. And while Fuller was focusing on state law, I found these concepts to be useful to my work and looking at non-state legal orders. So I'll just mention several of what he what he argued were necessary. And so one is that some agreement and the creation of general rules for application. Secondly, law must be public and available to people, to all the people. That law must be understandable and comprehensible. And following the law must be within the power of the people to whom that law applies. So those are just, four of the overall legalities that he works with. So he had his own objectives, his own context for setting out these legalities, which were for a state system. Kirsten Rundle from the Melbourne Law School has very helpfully expanded Fuller's scholarship. And she argues that each of these, that this is not a checklist. Each of these legalities includes necessary conditions for law. And she also argues that we have to think much more deeply about what the meaning of those conditions are. What does it mean to that they're required, and what does it mean for human relationships? So, part of her work is looking at dignity, that everyone, that the part of the structure and the validity of law itself is a recognition of the dignity of those people who comprise that society, and that their agency is an important part of maintaining law in that society. So my objective today is to make the argument that all law, including Indigenous law, has requirements and standards for how law is to be comprised to ensure that it's valid, that it's legitimate. When law fails to meet these legalities, it fails as law, and it becomes another form of ordering, usually political rather than legal. And there are many, many debates that take up these questions about, the failure or not of law. And these debates include Nazi law, they include apartheid, they include torture. But that's not what I'm going to look at here. What the laws that I'm most familiar with are Gitxsan laws. These are people who are in the northwest of British Columbia. The Gitxsan were one of the plaintiff groups in the tidal court action of Delgamuukw. I'm also familiar with Cree law. I'm Cree, but I've spent decades working with the Gitxsan. So, and through our work at the University of Victoria, we've worked with many legal orders across the country and have done so for years. So the requirements that are set out by Fuller and by Rundle for Indigenous law are similar in some ways. So if we look at what are some of those Indigenous legalities, they include the following, and this is not a checklist and it's not comprehensive. So dignity as legal agents, public law, it has to be part of a public memory that's accessible by the members of that group. And we can look at lots of examples of how that actually works. There's precedent, forms of public memory, again, that are accessible to people in those systems. Inclusion and accountability. Lots of the oral histories are concerned with abuses of power, for instance. Fairness and the right to be heard. Again, the oral histories emphasize over and over again that whether you're an accused or whether you're someone who's been harmed, you have the right to be heard in that society. And decision makers are required to make the best kinds of decisions possible on this case-by-case basis. And if they don't have the information, they're obligated to go and get it. So there's requirements for investigations, and there's requirements for the evidence that they need to accumulate. And safety of communities is another really important aspect in terms of the aspirations of the law. So these are some of the conditions. And when the law broke down, people had to lawfully rebuild. And again, we see this in these situations in our oral histories. So these are sources, legal resources that are drawn upon through the work that we do in order to cause us to think about substantively and procedurally about Indigenous law and its application in the world today. So I suggest that the first step in comparative law at this macro level is to think about and to begin discerning the legalities of and the conditions of law in another legal order. So historically, because of the different legal orders across North America, this is something that Indigenous peoples have always had to do. This is one of the requirements in being a people there. And we have to do this now with state law, is to understand those legalities. So, you know, this isn't about judging other legal orders against some state measure. It's about seeking to discern legitimacies and their logics and their aspirations, even when they look different from what we are used to. And so the discussions about what makes law law, what should law do, what should it be, like these are questions that are important not just for Indigenous peoples and the rebuilding of our citizenries. They're important for every Canadian, for all the reasons that the gentleman who opened this event has referred to, because of what's happening to our planet and the failure of democracy time and time again around the globe. So there's, you know, this is connected to civil society. It's connected to a flattening of citizenries that has to be attended to, that we all have to pay attention to, and to push back the anti-intellectualism that are a part of creating those problems. So Indigenous law and Indigenous peoples are not in a vacuum. We're part of this complex world, just as all of Australia is and all of Canada is. So at a micro level, we've been engaging with Indigenous law on in a number of different ways. So we have an Indigenous law research unit we established in 2012. We've been partnering with Indigenous peoples across the country to research and articulate and restate law questions that people have about their legal orders. So that work has been going on, that we create law reports that those communities own and which they then use for environmental assessment or government-to-government agreements or child welfare agreements or any number of things that they've decided are their priorities. We have a 4-year dual degree law program where students can graduate with an Indigenous law degree and a Canadian law degree. And we've so far graduated 2 cohorts. Every year now, there are going to be another cohort of 25 students. They're off articling, they're off working with government, whether it's Indigenous government or state government. They're working in courts and so on. Right now, we're building a national center for Indigenous laws. This center is basically doubling the size of our law school and is a place where, in addition to housing our Indigenous initiatives, is going to be a place where we facilitate critical conversations about Indigenous law. We have summer intensives. This coming May, I'm teaching a new course on Indigenous intellectual property, and this is based on work done over the last several years. And we usually offer Indigenous legal methodologies, but there's a lot of different options and courses. We have a very active judicial education program, and we work with most levels of court. We've been asked to put together judicial education packages which reflect the dual degree program, and so we have a framework for that. And currently, we're looking at stepping up the work with Indigenous law to to push the thinking and the work because it's slow. All of this is slow. Every law project that we partner with communities on takes a minimum of 2 years. And so part of our work has been to look at how do we expand that? And that's my current work. So when we think about what is it that, like, for Indigenous law, what does Indigenous law do? Similar things to other legal orders. It has to be comprehensive in order to meet and manage the messiness of collective human life. And so there has to be the ability to govern. You can't govern without law. So that's the same for Indigenous peoples. You can't be a people without law. Again, that's the same for Indigenous peoples. So, but there's areas of law that deal with families, with children, with human rights and fairness, with lands and with water, citizenship and belonging, disputes, international relations, and economies. And so those are the things that we work with communities on to write reports for them. All law has to do the really hard work of law. It has to solve problems that are real that people are experiencing. This deeper engagement with what law is for Indigenous peoples includes looking at what are the processes by which people determine a legal issue. They include determining who are the authoritative decision makers for different kinds of legal problems. What are the substantive and procedural rights within this society? What are the legal obligations and what are the guiding legal principles? All of these are what has to be articulated in ways that people can use them today or reinstitute them today or whatever it is that people are wanting to do. So, as I mentioned, communities use these in different ways, and so it's an ongoing area of work. So see the time here. The last couple of examples that I'd like to give, just of Indigenous law in the world. There are a number of justices, primarily lower court justices in Canada, who've begun to draw on Indigenous law to problem solve in the courts as sources of principled reasoning. So not looking at Indigenous law as evidence or fact, but rather how do you solve problems? And so this has been really exciting to see what people are doing and thinking about where might this go. So it's a new way for courts to engage with Indigenous law. The second example I wanted to give was just looking at for the Gitxsan peoples, one dispute, and looking at how did people manage the dispute? What were the different parts of that? And then I compared that with the common law trial process. And what I found was I drew on Gerald Postma's analysis of common law and its functions. And what I found was that the different aspects of what happened through the Gitxsan processes in terms of who was involved and what they did, all of the steps of the work and the problem solving, they met the requirements that Postma set out. So this is not to say that they looked the same. They looked very different. A courtroom looks really different than a feast that's held in a community setting. But the work that they did was the same. So there are lots of opportunities to look at those kinds of practical, pragmatic examples involving the work of law. There's much more to do in terms of exchanges and education. And I think that, again, this isn't just important for Indigenous peoples. This is important for everybody. This is important for work for everybody in Canada and for all the non-Indigenous people in Canada as well. So I look forward to your questions.
Thank you very much, Professor Napoleon. We'll have the questions, I think, at the end of the speeches, and then we can draw together some themes. Our next speaker is Ms. Marcelle Burns, who is the Associate Dean of Indigenous Leadership and Engagement at the University of Technology in Sydney in its law faculty. Marcelle is a Gomeroi Gamaroi First Nations woman and has had over 25 years experience in the field of Indigenous peoples and law, both as a lawyer and as an academic. She has worked in criminal law as a solicitor for the Aboriginal Legal Service, New South Wales and ACT, civil law in the Legal Aid Commission of New South Wales, and in private practice assisting with native title claims. From 2015 to 2018, she was the project leader of the Indigenous Cultural Competency for Legal Academics program funded by the Australian Government Department of Education and Training. Her work on Indigenous cultural competency in law curricula has been acknowledged by the University of New England's Faculty of Science, Agriculture, Business and Law Award for Excellence in Teaching and Learning Research in 2018. And I'm delighted to ask Ms. Marcelle Burns to speak to us today.
Thank you. I'd just like to thank you, Uncle Michael, for your welcome to country. And also like to start by acknowledging the traditional owners of the country on which we meet today, the Gadigal peoples of the Aurora Nation. And thank you, Val, for your very inspiring speech. I think most people would have already gathered we've got a long way to go in Australia to catch up with what's happening in our in Canada. So what I'm talking about today is First Nations and state sovereignties in Australia and challenges for enduring courts in changing times. And I want to consider the recent High Court decision of Love and Toms versus the Commonwealth about and how that deals with the treatment of Indigenous sovereignty. So the High Court's decision in Love, Toms and Commonwealth, or Love and Toms for short, has been celebrated as acknowledging the special relationship of First Peoples to this continent now known as Australia. The nature of this special relationship, however, was limited to the extent that it prevented Aboriginal people from being deported from Australia in circumstances where they were not Australian citizens. So this analysis sits within a broader international context where nation states have been urged to address the harmful legacies of colonialism. In 2011, the United Nations Permanent Forum on Indigenous Issues has argued that whilst some domestic courts have acknowledged the colonial origins of assumed state sovereignty based on discriminatory doctrines such as terra nullius, with reference to the High Court in Mabo, that those same courts have failed to give full and fair consideration to First Nations pre-existing sovereignties. The Permanent Forum therefore urges state parties to repudiate and provide remedies for harmful colonial doctrines and elaborate a judicial framework that is consistent with international human rights law. More recently, a few years ago, the United Nations Human Rights Council has urged member states to take concrete steps to address the negative impacts of the legacies of colonialism on the enjoyment of human rights, and especially the rights of Indigenous peoples. The Human Rights Council has also encouraged member states to promote the rights of First Peoples through treaties and by implementing the United Nations Declaration on the Rights of Indigenous Peoples through legislation and constitutional reform. Canadian legal scholar Kent McNeil also argues there is a need to reconcile assumed state sovereignty with pre-existing Aboriginal sovereignties, as expressed by the Canadian Supreme Court in the case of Haida Nation versus British Columbia. McNeil contends that where courts have failed to give full and fair consideration to First Nations sovereignty, then the only way to legitimise state sovereignty is through treaties with First Nations. For McNeil, such treaties must also create the conditions of decolonisation by becoming a source of intersocietal laws, coexisting sovereignties and the sharing of territory. So these issues have a particular significance at the present time in Australia, with the federal Labor government committed to implementing the Uluru Statement from the Heart in full, which calls, as most of you would know, for a First Nations voice to Parliament, and the establishment of a Makarrata Commission to oversee truth-telling and treaty-making with Australian governments and First Nations. So this paper will examine the judicial reasoning in Love and Toms on the issue of First Nations and state sovereignty. I will argue that Love and Toms represents an affirmation of state sovereignty which is out of step with contemporary international legal perspectives on the need to address the harmful impacts of colonisation, and that this denial of First Nations sovereignty is also inconsistent with our perspectives that our sovereignty has never been ceded and continues to coexist with state sovereignty, which is the basic sentiment of the Uluru Statement from the Heart. So in this paper, I'll just go through the facts of the case and the key findings on the special relationship of First Peoples to country and their constitutional status, and then address the reasoning on the issue of First Nations and state sovereignty. And my written papers elaborates a bit more on treaties and the Uluru Statement, but given the time constraints, I'll then just draw some conclusions on the challenges for the role of the judiciary in what I hope will be a post-voice and post-treaty Australia. So the facts of the case in Love and Toms were that 2 Aboriginal men were subject to deportation orders, being born overseas and non-Australian citizens. Having been convicted of criminal offences, they were no longer deemed to meet the character test under the Migration Act. Daniel Love, a Gamilaroi man, and Brendan Thomas, a Gungari man and native title holder, were subject to deportation orders on the grounds they failed to meet the character test following criminal convictions. The plaintiff submitted that the Commonwealth's legislative power with respect to aliens under Section 51(19) of the Constitution did not apply to Aboriginal people who could not be regarded as aliens according to the ordinary meaning of the word. They argued that Mabo and Queensland No. 2 acknowledged the special connection of Aboriginal peoples to Australia, which was inconsistent with treating them as aliens. The plaintiffs asserted that a special constitutional category of non-citizens, non-aliens should apply to them, and that membership of this category could be determined using the tripartite test of Aboriginality. It's been adopted by governments and the courts, and in Mabo, being biological descent from Aboriginal ancestors and mutual recognition of a person's Aboriginality by themselves and by elders or persons enjoying traditional authority from their particular group. The High Court found in favour of the plaintiffs by a slim majority of 4-3. In reaching this conclusion, however, both the majority and minority judges affirmed the indivisible sovereignty of the colonial nation state and consequently denied any enduring First Nations sovereignty, which for me is problematic. So on the questions of their status, whether Aboriginal people could be regarded as aliens or not, the majority judges, Justices Bell, Edelman, Gordon and Nettle, found that Aboriginal people could not be treated as aliens under the Constitution due to their unique spiritual and cultural connection to Australia. They found that the common law recognition of native title was also inconsistent with the finding that First Peoples were aliens. Justice Gordon found that the deeper truth recognised by Mabo was that First Peoples' connection to country was not extinguished by European settlement. It is a two-way spiritual connection to land, where the land owns the people and the people are responsible for the land. Justice Bell found that Aboriginal people cannot be treated as aliens due to the special cultural and spiritual connection of First Peoples to country, and therefore they cannot be said to belong to another place. She also found that international law, including the Declaration on the Rights of Indigenous Peoples, recognises that Indigenous peoples have a unique connection to their lands, which may impose a limit on state power. For Justices Gordon and Bell, the position of Aboriginal peoples is sui generis, which excluded them from being treated as aliens. According to Justice Edelman, First People cannot be treated as aliens because they had communities, societies and ties to land, now recognise their connection to country, which meant they belonged to the Australian political community. For Justice Nettle, following Mabo, he said, the common law, and I quote, in Australia recognises, and in truth had always recognised, traditional laws and customs giving rise to native title rights, which had survived the Crown's assertion of sovereignty, subject to the sovereign power to extinguish native title. And logically anterior to that recognition is the existence of Aboriginal societies, where that society is continuously united in their acknowledgement of laws and customs. Accordingly, such status is inconsistent with alienage because to classify members of an Aboriginal society as an alien would be to recognise that the Crown had the power to tear the organic whole of the society asunder, in his words. The minority judges rejected the plaintiff's arguments. They could not be regarded as aliens due to their Aboriginality and connections to country. They found that the meaning of alien could only be understood as the antonym of the statutory definition of citizenship under the Australian Citizenship Act. For the minority, determining questions about citizenship or alienage is not a proper exercise of the judicial function, but a matter for the Parliament to decide. The minority judges also found that the common law's recognition of native title was irrelevant to First Peoples' constitutional status, because native title relies on a connection to particular lands and waters based on the traditional laws and customs of distinct Aboriginal groups, which was not analogous to membership of the Australian body politic. For the minority judges, First Peoples' connections to country and traditional laws and customs have no legal significance beyond the recognition of native title. First Nation laws are treated as questions of fact and not laws which are valid and legitimate on their own terms. In my view, the High Court's judgment in Love and Toms is also problematic because it affirms the classical positivist view of the indivisible sovereign and in doing so denies First Nations sovereignty. For the majority judges, the recognition of First Peoples as members of the Australian body politic was entirely consistent with state sovereignty. For Justice Gordon, the recognition of First Peoples as members of the Commonwealth denies that Aboriginal people retained or can now maintain a sovereignty that is distinct or separate from any other part of the people. Accordingly, such recognition does not fracture a skeletal principle of our legal system, drawing on the words of Justice Brennan from Mabo, and to ignore this recognition would render the determination of the constitutional question incomplete. For Justice Bell, this limitation on state power does not deny the sovereign power to exclude aliens generally. For Justice Nettle, while the acquisition of sovereignty is not judiciable, its consequences are, and are determined, and I quote, by common law doctrines grounded in the law of nature and now developed in step with customary international law. According to Justice Nettle, this meant that settlement doctrine, now applied in Australia, which for First Peoples meant living under the Crown's protection and the jurisdiction of the common law. Justice Nettle adopted the view in Mabo that if the peoples of ceded and conquered territories became British subjects, so did people in settled territories because they could not have owed allegiance to any other sovereign. He also confirmed the High Court authorities which held that Aboriginal people undoubtedly remain subject to and protected by the system of law in Australia. Thus, Justice Nettle denied any enduring First Nations sovereignty because in his view, First Peoples owe allegiance to the colonial nation state. Justice Edelman drew a distinction between First Peoples in Australia and Native Americans, with the latter recognised as distinct independent political communities retaining their original natural rights as the undisputed possessors of the soil, and he found that despite the limited recognition of Aboriginal political organisation in Australia, Aboriginal people should not be regarded as aliens because First Peoples lived in societies governed by laws and customs which the common law recognised as entitlements to land. Here the majority judges reaffirmed the classical positive view of the illimitable and indivisible sovereign of the colonial nation state. They upheld the view in Coe and the Commonwealth 1993 that there can be no sovereignty adverse to the Crown. Recognition of First Nations as distinct independent political societies was completely off the table. The minority judges found that the proposition that elders or persons with traditional authority could determine membership of Aboriginal societies and consequently their constitutional status was an unacceptable challenge to state sovereignty. For Justice Keifel, to accept this view would be, and I quote, attribute to the group the kind of sovereignty which was implicitly rejected in Mabo and expressly rejected in subsequent cases such as Coe and the Commonwealth and Yorta Yorta and Victoria in 2002. Justice Keane found that to allow Aboriginal groups this power would afford them a measure of political sovereignty beyond the scope of native title, which is ultimately subject to the Crown's sovereign right to extinguish. According to Justice Gagala, the argument that Aboriginal elders may decide who is an alien came perilously close to an assertion of First Nations sovereignty, albeit not to claim independence from, but to argue an enduring connection with the Australian body politic. The minority judges also affirmed the High Court cases which have consistently rejected First Nations sovereignty or status as distinct political societies or domestic dependent nations. For the minority judges, there is nothing in the Constitution to support the recognition of any unique status for First Peoples. According to the minority judges, constitutionally speaking, First Peoples don't have a leg to stand on. The response to the High Court's decision has been polemic. The decision has been welcomed by many as an acknowledgement of the deep spiritual and cultural connection that First Peoples have to country and a unique constitutional status. Conversely, the decision has been criticised as a direct assault on the sovereignty of the Crown, aggressive judicial activism, and creating a race-based constitutional status, which is out of step with notions of formal equality. Here I'll just briefly outline some of the key arguments relating to sovereignty and the status of First Peoples from the academic literature. So the High Court's decision in Love and Toms has been interpreted as not only acknowledging a unique constitutional status, but implicit recognition of First Nations sovereignty. Shireen Morris argues that while the majority judges were at pains not to acknowledge First Nations sovereignty, they articulated a more nuanced conception of surviving sovereignty, which is implicit but not explicit in the Constitution and yet to be fully realised. This notion of surviving sovereignty was based on the decision of the International Court of Justice in the Western Sahara Advisory Opinion. In my view, this interpretation is wrong because the ICJ found that the territorial claims of Spain and Morocco based on terra nullius were not lawful under international law, and also because the Western Sahara peoples did not know an allegiance to any other sovereign. Shira Cordia also argues that the majority rejected Indigenous sovereignty and the unique constitutional status recognised by the court is rooted in a notion of distinct Aboriginal sovereignty. On the other hand, Eddie Sinnott argues that while the judgments differed on the significance of native title recognition to other areas of law, they also confirmed a unitary political community and sovereignty that rests with the Crown. Lisa Arcioni and Kirsty Gavo also argued that the decision in Love and Toms does not damage the standard narrative of monistic and absolute sovereignty of the colonial nation state. Rather, it is consistent with the judicial tendency to characterise Aboriginal societies as racial communities and not political entities, which Arcioni and Gova assert is a mistake of fact. In my view, the argument that the High Court recognised First Nations sovereignty by implication is difficult to reconcile with the majority judgments, which found that the unique constitutional status of First Peoples was entirely consistent with state sovereignty. Both the majority and minority judges also affirmed the High Court authorities which have rejected any form of First Nations sovereignty, surviving or otherwise, because in their view, First Nations have never constituted distinct political societies capable of exercising sovereign power, and therefore First Nations sovereignty cannot be recognised by the common law. If anything, Love and Toms affirms this position absolutely, being the most comprehensive statement on First Nations sovereignty by the High Court to date. While this recognition has been posited as an acknowledgement of First Peoples' unique cultural and spiritual attachment to lands, it is to some extent also illusory because it also affects an erasure of First Peoples' laws and customs which give life to this connection, yet are deemed to not have any legal effect beyond providing the factual basis of right claims before the nation state. The High Court's denial of First Nations sovereignty is also entirely at odds with First Peoples' perspectives that our sovereignty has never been ceded and which question the legitimacy of the colonial nation state. So where does this leave us? Perhaps, according to McNeill, we should be looking at treaties to overcome this anomaly in the common law. But if you want to see my views on that, you can read the written paper. I'll just wrap up here with some conclusions. Huh? Yeah, cool. Okay, the High Court's denial of First Nations sovereignty is out of step with international human rights law and the call for colonial courts to give full and fair consideration to First Nations sovereignty. This denial is problematic because questions about the legitimacy of assumed state sovereignty remain unresolved. McNeill argues that where courts have failed to give full and fair consideration to First Nations sovereignty, then the only way to legitimise state sovereignty is through treaties. These issues have particular significance in present-day Australia with the Uluru Statement calling for First Nations to Parliament, truth-telling and treaty-making. Anyway, the challenge for enduring courts in changing times is whether judicial reasoning can remain untouched by the Uluru Statement and treaty-making in Australia. While the proposed voice to Parliament is non-judiciable, we must ask whether judicial reasoning can remain detached from its social and political context. This is a challenge for jurists who dare to ask the question, what are the consequences for First Nations and state sovereignty in a post-voice and post-treaty Australia? Can we imagine a time when the Australian common law recognises, and in truth had always recognised, the inherent sovereignties of First Nations? Thank you.
Thank you very much, Marcel. And it's a fabulous paper. And I commend you for being the only panellist to produce paper. Which brings me to our last panellist today, Justice Joe Williams from the Supreme Court of New Zealand. Justice Williams, Sir Joe Williams, was appointed to the Supreme Court in 2019, making him the first Maori lawyer to be appointed to the Supreme Court. His Honour graduated with a law degree from the Victoria University of Wellington and later with a master's degree from the University of British Columbia with honours. He became the Chief Judge of the Maori Land Court in 1999, the youngest person to be appointed to this position, and was later appointed as Deputy Chairman of the Waitangi Tribunal in 2000, later becoming Chairperson in 2004. He was appointed as a High Court Judge in 2008, a Court of Appeal Judge in 2018, and is now sitting on the Supreme Court, having, as I said, been appointed in 2019. He was the first Te Reo Māori speaker to be appointed to the Court of Appeal. Following his appointment, he was appointed a Knight Companion of the New Zealand Order of Merit for services to the judiciary and for bringing a unique blend of legal intellectual challenge, a rigour and tikanga Māori to his role. Justice Williams is speaking last this morning because when I asked the panellists what order they wished to speak in, he said he had no concerns at all, other than that he had to be last. So, Justice Williams.
E te pāpā, Michael, tēnei ka mihi ake ki a koe, te āhuatanga ki ngā mihi mai nei, ki runga ki tēnei whenua, me te ahi kā e kā tunu ana, whakaatu ana I te mana o ngā mātua ki runga ki tēnei whenua. Uncle Michael, thank you for making us welcome among you, as you represent the voice of those whose fires of occupation and authority burn still in these lands, despite that all that has gone on. Nō reira, tuku a rātou kia piri ki a rātou ko tātou, e piri nei ki a tātou. So let your ancestors be joined with my ancestors. And by their joining, can it be said we, their living faces, their speaking mouths, their seeing eyes, have also met. Tēnā koe, o tira tēnā tātou katoa. The welcome to country is a newish innovation in my experience on this continent. It's become ubiquitous. Every conference, every major meeting of people, key sporting events, including a big one that's playing out at Penrith tonight or this afternoon,
Go the Pan.
that if I finish this speech in time, I'll be at, all begin with a welcome to country. It's not dissimilar to what we call the whakatau back home. And there's always a danger that these forms of formality can degrade into cliche. But the welcome to country is deep in meaning and power in ways that I think are relevant to the discussion we're having this morning. Because they establish who is the host and who is the guest. They acknowledge implicitly and sometimes explicitly that there was and continues a prior order, picking up on the discussion we've just had, with prior rights, there was prior power. And that the host is offering the guest the privilege of their hospitality. Despite, it might be said, the misbehavior of the guest over a long period. So the welcome to country is powerful. In legal terms, I suggest. So in 1823, when the Third Judicial Charter established the Supreme Court of New South Wales, read out, I guess, just down the road on Elizabeth Street in May 1824, neither Governor Brisbane nor the newly minted Chief Justice Forbes had a welcome to country. In fact, I've discovered this morning the first welcome to country came 175 years later, which tells you something about the guest. But at least there was an opportunity to offer one in 1998. In fact, Chief Justice Forbes noted the law a little later, I think, maybe a few days later, I haven't quite pegged the date, but someone here may know it. The law of New South Wales, the colony then, is the law of England. And the courts of New South Wales are the courts of Westminster. So given all that, what's my job? Well, I kind of feel like a country cousin. One of those uncles that gets invited to all the family do's, not particularly well known by the family, definitely not well understood, and a little weird. The uncle that sits in the corner sipping tea while everyone else is having a good time, that's me. You see, because on the 14th of January 1840, Governor Gipps swore in Captain William Hobson as Lieutenant Governor of the colony of New Zealand. And on the 6th of February 1840, a treaty was entered into between the local chiefs and the Crown. And on the 21st of May of that same year, Hobson got around to declaring British sovereignty over New Zealand. It was always assumed, since this guy was a lieutenant governor, that sovereignty lay with New South Wales and its English law and its Westminster courts. On the 16th of June 1840, the New South Wales Legislative Assembly extended all New South Welsh laws to New Zealand. That remained the position. So, whoever the Chief Justice was in 1840 of New South Wales was the Chief Justice of New Zealand, and Governor Gipps was the Governor of New Zealand, William Hobson being only his lieutenant. That state of affairs lasted for 13 months. When New South Wales jurisdiction was removed and the Supreme Court of New Zealand was created, on the 1st of July, 1841. So for 11 months, we were part of you. So happy birthday to us. That's what makes me feel like the weird uncle sitting in the corner. In New Zealand in 1841, the courts tiptoed in. The colonial authorities did not assume jurisdiction over the Maori, even in interracial disputes. In 1841, after the appointment of the first Chief Justice, Sir William Martin, who was, it must be said, a progressive in the model, I suppose, of the missionaries then at the time. But these Maori were rather well armed, and mere declaration of law wasn't going to make much of a difference in reality, as it didn't wherever Indigenous people were well armed and formidable, both on this continent in the 18th and early 19th century, and on the American continent in the early days of that colony. So, in December 1842, when a 16-year-old boy named Maketu Te Whare Tōtara, who had worked on an island in the Bay of Islands, then called Roberton Island because it had been purchased by John Roberton and his wife, Mrs. Roberton, who had 3 children. When Maketu Te Whare Tōtara, at the end of 1842, got into a fight with the manager of the farm on Roberton Island, a Mr. Thomas Bull, aged 30. I should have said to you, you can tell that I've got scribbled notes here and I'm not reading a paper. John Roberton died, leaving Mrs. Roberton, the widow, in charge of the farm. Hence, Thomas Bull was there managing the farm. Now, young Maketu was the son of a chief from one of the inland tribes, a chief named Ruhe. And he had been sent there to work for Mrs. Roberton and Mr. Bull. Mr. Bull, it seems, was aptly named, and he bullied young Maketu to within an inch of his patience. At one point, towards the end of 1842, it all got too much. There was a fight over young Maketu's pay, and Bull kicked Maketu. Now remember, Maketu was the son of a chief, not used to being treated this way, so when the family all went to bed, Maketu Te Whare Tōtara picked up an axe and clove Mr. Bull's skull in 2. Having done that, it appears that he then, in order perhaps to cover his tracks, killed the widow and the 3 children, one of whom, and this is key, was an adopted child named Isabella Brindle. She was a half-caste granddaughter of the Big Cheese in the Bay of Islands, a chief named Rewa, who signed the Treaty of Waitangi 2 years earlier. Mrs. Roberton had custody of the child because Rewa's daughter Moewaka had died, and her husband, a whaler, had gone off whaling, leaving the child to be raised by Mrs. Roberton, a relation. So it turns out that the son of a chief kills not only a bunch of white settlers, Pākehā as we call them, but the granddaughter of a chief. There is a problem. A big meeting is held, 300 people attend it to decide what local Māori are going to do with Maketu. They refused to give him up to the local magistrate, Beckham. And Beckham, unsurprisingly, decided that the wisest thing to do was nothing. Then on the 16th of December 1842, 20 leading chiefs of the Bay of Islands meet, including Ruhe, the father of Maketu, and Rewa, the grandfather of the young girl. They send a letter to the governor, signed by all of them, saying, "You have Maketu." Why do they do that? Because their tikanga, their law, their custom would have required war. And that was in nobody's interest. So Maketu's own father very reluctantly signs the letter, as does Rewa, a very powerful chief who could have cloven Maketu and his father and all of their tribe if he'd wanted to, but he did not want to. It suited them to hand this over to Chief Justice William Martin to deal with, to minimize the damage. So the letter was sent. And Maketu Te Whare Tōtara went on trial for murder in the Supreme Court, as it was then called, in Auckland in March of 1842. I think I said December 1842. I meant December 1841. Interestingly, this is a side story. Oh, I'm running out of time. Hone Heke, who was at the meeting of the 20 chiefs, refused to sign. Now, those of you who know a little bit about New Zealand colonial history will know that Hone Heke led the first campaign against imperial troops in 1845. His view was that this was a Maori matter and Maori law should prevail. But he got outvoted. He picked up arms 3 years later and had his way. William Martin presided at the trial. William Swainson, the Attorney General, prosecuted, and a man named Brewer appeared for the defence. He complained, actually to the jury in his final address, that he had not had an opportunity to take instructions from his client or even speak to his client. He'd been instructed by the government an hour before the trial started. But actually, I've read his final address. In the circumstances, it wasn't that bad. Brewer argued there was no jurisdiction. Unsurprisingly, the Chief Justice refused the application to non-suit, if that's the correct term for it, particularly given that he had the letter from the 20 chiefs in his back pocket. Then he applied, Mr. Brewer, for a 50-50 Māori Pākehā jury, and Sir William Martin refused that too. The evidence called was from both Pākehā and Māori. It was circumstantial, but for an apparent confession that Maketu gave to a settler who admitted that he could not speak Māori. Maketu couldn't speak English. Nonetheless, the jury convicted, and he was hanged, and a war was averted. Not between Māori and settler, but between Māori and Māori. So, in those early days, the courts performed a useful, if imperfect, function at the interface between settlers and the indigenous people. By the 1850s, when the settler population in my country had changed dramatically, substantially due to the Irish potato blight, So that by 1858, settlers were a majority, the entire complexion of the law and the approach of the courts changed. The Treaty of Waitangi, which contained, interestingly, a promise of self-government, explicitly in the Māori text, the word used was tino rangatiratanga. Also, the word used, if you're Catholic, in the Our Father, and if you're a Protestant, in the Lord's Prayer, for the kingdom of God. So you can see how powerful the guarantee was. Came to mean nothing by 1877, after the land wars had been fought and won by 12,500 imperial soldiers and half again militia. The Chief Justice Prendergast then was able to say that to the extent that the Treaty of Waitangi purported to be a treaty of cession, it must be regarded as a simple nullity, having been entered into with savages who lacked the capacity to agree the same. Also, interestingly, there were some cases early on that accepted Māori custom should be applied in the common law. The beautiful irony is those cases were in disputes between settlers. There was a fight over a whale, a case called Baldock and Jackson that came before the then Chief Justice Sir Robert Stout. Who owned the carcass? It was worth 200 quid. Apparently someone had harpooned it and then left it to float so they could go and chase another whale. And when they got back, another whaler had hooked up the carcass and taken it ashore. The loser sued the winner. The argument for one side was that whales are a royal fish. They belong to the Crown. Therefore, the plaintiff could not claim ownership. So Robert Stout said the Treaty of Waitangi guaranteed rights to Māori fisheries, and Māori were accustomed to chasing whales. Therefore, the royal prerogative is displaced in the context of this colony. No Māori in sight. But in disputes between the state and Māori, invariably the state won. The courts became unapologetic instruments of the colonial project. The establishment of the Native Land Court to ensure that what remained of Māori land from 1862 on would transfer into settler hands as quickly as possible is proof of that, as is the Supreme Court's view of the status of the Treaty of Waitangi. So by the second half of the 19th century, if you were to have a conference called Enduring Courts, and what's the change thing?
Changing times.
Enduring Courts in Changing Times, it would not necessarily mean what we would take it to mean if you were Māori. Who's enduring what would be the question in the first part of that title. And Māori would be, the Māori position would be they are forced to endure the courts, not that the courts are enduring. And there was a great deal of anger and opposition, even after the wars had been fought and significant tracts of land confiscated. The thing about Māori law, like all Indigenous law, is it is performative. Statements of law are performed. Now, we who operate in the common law system do that too. We put blonde wigs on, at least we used to. We don't in my country anymore, but and you know, those outfits, that's performative. The tip staffs get to wear their long black coats, which are very cute. I wish our tip staffs had those. And the judges get to sit up there and the lawyers down there, and if there's a dock, which there isn't in a Banco court, the dock would be in a subordinate position, all of that performative. 5 minutes? Right. There's a chief from the East Coast called Tutanihoniho who became so frustrated with the operation of the law that he composed a haka, a war dance, to be performed in front of the magistrates' court in the town of Gisborne. Overnamed Gisborne, it had formerly been known as Turanganui Kiwa. And it goes like this. Pongaroi, pongara, kotata ki mai te wale o ngā ture kawiri yara. Te ma muri kawiri yara. Ngau nei o nā reiti. Ngau nei o nā tāke te taia te ue. Hei, ya ha ha. Padu ai te wenua. Hei. Waka taua I ngā ture. Hei, tei, ya, ha, ha. Nā ngā me mara te ko huru. Nā te kawana te ko heri, heri. Karara runga ture. Karara pa te pua te torori yaue. Kaure hoki ra te mate o te whenua. Te makere hoki ra rorai. Ai, ya, ha, ha. Ai, ni tonu mai runga I te kiri utu mau mai ai. Hai, ti pare, rumbo te whariri. Ai, ya, ha, ha. Ai, tahuna mai au ki te waka heke totokoa. Ai, ki te ngā kau o te wenua nei. Ki te kōra, au e taukuri e, hei ya ha. E kotu hiki tia, kotu hapa inga, raroi te wero o te mau, haukiti. And so on. In which he says, you know, you people came here telling us that we were less than you, complaining that we ate our own head lice, that we engaged in ugly behaviors, that we tattooed our faces, and so we followed your ways. But you lied. You came to steal our country. Your parliament, your judges, and your laws have turned us into slaves. Pōko kohua, boiled head. Kaura mokai, slaves to gold. He endured the courts, as did his generation. But interestingly, 1 minute. I've only actually got halfway through my paper, but I haven't even got to the 20th. Yeah. Anyway, don't worry. This bit is important. At the same time, this happens in 1878. That haka is still performed today. You can imagine 40, 50 people, male and female, delivering those lines and the power of that. At the same time, about 1883, a great prophet and political leader named Te Kotia Rikirangi was at a low ebb, shall we say, at a strong community supporting him as a religious leader. He had been arrested by the Crown in 1864, wrongly charged with, actually never charged, wrongly accused of rebellion against the Crown. In fact, he had fought on the Crown's side, but that didn't matter. He was transported to the Chatham Islands without charge or trial, left there for 2 years until he and his community hijacked a ship and came back to New Zealand and headed inland, chased by colonial militia. Most of his group were executed without charge or trial on top of a very famous hill called Ngātapa. And he spent the next decade running from the soldiers. And he was a man who the story is a very powerful story, as powerful as any colonial story you'll ever hear. He was a man who owed nothing to the law. In fact, the law had brought him low. And he was a great composer. He composed traditional songs that basically told the story of his life as it was happening. So we have these equivalent of affidavits running through this man's life. And one of them, composed in 1883 and still 1883 and still performed, has this beautiful line in it. Ka kuhuau ki te ture, hei matua mo te pani. I seek refuge in the law, for it is apparent to the oppressed. I've never understood that, except in this way. He knew, obviously, that war didn't work. He knew that he was at the mercy of the new colonial order. And he knew, at its best, the new colonial order could well be his salvation. But it needed to be at its best. And 200 years on, for you, and a little less for us, but not much less, we're still searching for our best. And we still haven't found it. Tēnā tātou.
I know I promised you an opportunity to ask questions of our panelists at the end during this session, but there's been an adjustment to the program, and we'll have questions in relation to this session and commentary and a response from our attendees in New Zealand after the morning tea adjournment. So we will resume at 11:30. Thank you.
You might get something.
Now we're back on. They might be.
Well, can we resume? In this session, I'm very pleased to be able to introduce to you Professor Kate Warner and Tim McCormack, who are sitting in a conference room, as you will see, in Tasmania. And they're going to give us some commentary and responses in relation to the session, and then we'll have general questions. By way of introduction, and you probably will already know that Professor Kate Warner is an Emeritus Professor of Law at the University of Tasmania, a Fellow of the Australian Academy of Law and of the Australian and New Zealand Society of Criminology. She was the first woman Governor of Tasmania. And she began working full-time as a lecturer in the law faculty of the University of Tasmania in 1981, and there's been a series of firsts in that regard. The first woman dean of the law faculty in 1992, the first woman head of the School of Law in 1994, and as I said, the first woman governor of Tasmania. Kate's nationally and internationally recognised for her expertise in sentencing. She's won several awards for her work and written articles and a book in relation to that. Professor Tim McCormack is a Professor of Law at the University of Tasmania. He's also the Special Advisor on International Humanitarian Law to the Prosecutor of the International Criminal Court in The Hague. He's also a Fellow of the Australian Academy of Law, and a Director of World Vision Australia. I've just been I've got the haka ringing in my head. Between 2002 and 2006, Tim acted as amicus curiae on international law matters to the judges of Trial Chamber 3 of the International Criminal Tribunal for the former Yugoslavia in The Hague for the trial of Slobodan Milosevic, and he has provided international humanitarian law advice to Major Mori for the defence of David Hicks. In 2021, Tim assisted Professor Warner in preparing a report on the pathway to truth-telling and treaty for the Tasmanian Premier, which explored options for an agreed way forward towards reconciliation. In the process of preparing the report, the two spent months travelling across Tasmania and consulting with Tasmania's Aboriginal people to understand their thoughts on and aspirations for treaty, truth-telling and reconciliation, and to identify possible pathways towards these goals. So I'm very happy to throw the floor over to Professor Warner and Professor McCormack. And as a little bit of a spoiler, they have promised a rendition of the Tasmanian devil mating calls.
Did we?
Her former Excellency and my former professor at law school, as an undergraduate student actually, and I are gathered together today to join you virtually, but we're on the land of the Muwinina people, and we'd like to start by acknowledging them as our traditional owners and custodians of the land on the western shore of the Derwent River, stretching from the north around Bridgewater to the south around Kettering. Muwinina people were part of the Southeast Nation language group and interacted with the Nuanone and the Malakadi as part of bands of this nation. And we would normally, of course, in making an acknowledgement of traditional owners and custodians, acknowledge and pay our respects to elders past, present and emerging. But one of the great tragedies of colonial invasion and dispossession in Van Diemen's Land, Tasmania, was that there are now no known descendants of the Muwinina or of many other of the bands of Tasmania's Aboriginal people. And that is a profound loss of culture and history and law and custodianship of the land on which we meet. And it's important to both recognise and to lament that tragic part of our history. But it's the last thing that I would like to do to communicate that somehow or other the Muwinina no longer have a presence here, because we understand that the spirits of their ancestors cared and nurtured this land for 40,000 years, are still here And so much of what Kate and I and others who are privileged to call this part of Tasmania home love about this place has to do with the imbuing of the spirits of the old people that are here, the beautiful physical features that we love and that have been cared for so carefully. So I'm going to hand over to Kate to explain a little bit about what we're on about here. Thanks.
So thanks, Tim, and thank you for your acknowledgement of country. Tim always does such a wonderful acknowledgement. I think it's an inspiration to all of us who try to do something similar. But I would just like to open by thanking the organisers for including this first plenary session dealing with the courts and the law and Indigenous peoples. And this is particularly because I know for the official bicentenary celebrations in 1988, there was no official recognition of the devastating effects of colonisation on Indigenous people. So it's good to see that in those years we have at least moved ahead. So what Tim and I want to do is to first of all explain why it is that we've been asked to be the commentators. And we guess it is because, as the judge has suggested, that we were involved in a project on pathway to truth-telling and treaty for the Premier. So we did this in 2021, and it was a wonderful experience. We can, if we have time later, perhaps talk a little bit more about that. But what we want to do is to of course, respond to the papers that we've heard this morning. But probably a bit of a modest disclaimer, I'm not a constitutional lawyer, and Tim is an international criminal lawyer, so we don't necessarily feel that we've got a huge amount of expertise in this area, but we've certainly been fascinated by the three presentations that we've heard this morning. So starting first of all, we'd like to make some comments about the wonderful paper that Professor Val Napoleon gave. And I think our first impressions were, oh my goodness, what a long way to go we have in Australia when we compare with what is happening in Canada. So it was a really inspiring presentation. And I think we were really fascinated with the idea of, particularly, when Val was talking about the micro level, about the fabulous courses that they are running in Canada, that they have actually joint degrees between Indigenous law and Canadian law. And we were comparing between ourselves the differences between our very meagre efforts to try and bring in Indigenous law in our teaching. And I know Tim's got some comments about
Yes,
that.
Val, it's fascinating to me when we talk about indigenising our law curricula in law schools in Australia. What we're really talking about is introducing either Aboriginal or Torres Strait Islander perspectives on relevant areas of the law, or the extent to which Aboriginality or indigeneity has been identified by courts in the relevant subject matter of the unit, or sometimes Indigenous perspectives from commentators in that field of law. But the idea for us that indigenising the curriculum might mean developing an entire law degree that students were offered as a dual degree, one in Canadian First Peoples law and one in Canadian civil law, is a wonderful concept, but one that, we could only, we've got a long way to go before we'd even get close to that here.
Yes,
I know that
when we deal with it, we're really talking about our law and the concessions it may make to Indigenous law, not to looking at Indigenous law as a whole.
and that's without the haka to say you stole our land from us and you lied to us.
Yes. Yeah.
I know that, Sir Joe, you probably know a little bit more about this, but my understanding of the Board of Legal Education in New Zealand is that they've directed the 6 law schools in your country to, I can't remember whether it's 2025 or 2026, to introduce Maori law, and that project is called Indigenising the Curriculum, but it's not in the simplistic way that we understand that concept here, but is to teach a bijural system, and that all law graduates from New Zealand law schools will know Maori law as part of their law degrees. I think that's a wonderful project, and I'm really looking forward to learning a bit more about that.
Yeah. And I think Tim and I would be really interested to know a little bit more from Val about how they go about really getting all the information about these different law groups around the country. So we heard that there were some 20 linguistic groups, and so there are many different bodies of law out there. And just the idea of collecting that must be a huge task. So I think how they go about that, what sources of law do you use to gather the information about these laws? I think that would be really interesting to hear about that from Val.
Yeah. And Val, you finished up your really wonderful presentation with the observation that the work that you and presumably other law schools in the country are working on is not just important for Indigenous communities in Canada, but also important for the entire country and for non-Indigenous communities. And that observation really resonated with us. We feel that very keenly. We think, we completely agree with you about that any work that goes on to bring Aboriginal, Torres Strait Islander, Indigenous perspectives to bring their understandings, we actually as non-Indigenous people desperately need that. The industrialised world needs that as we face climate change crisis. And yeah, I guess it's something that both Kate and I yearn for, a deeper appreciation and maturity of attitude to reach out and receive what knowledge and experience we can draw on to live in a better way.
Yeah, I think the only progress we've made in Australia in relation to that is in relation to understanding how well Indigenous people cared for country and how much we should learn from that. So there's a lot of revival in terms of understanding about care for country and coal burning and how beautifully they cared for Tasmania, so that when it was colonised, the settlers really couldn't believe what they saw. It seemed like beautiful parklands through the Midlands, which of course they have been able to exploit.
Yeah. Move on to Marcel.
We should move on to Marcel. So Marcel, thank you for your great paper. And thank you for giving us the opportunity to read it before too. I was really grateful for your wonderful analysis of love. I think that was so helpful. I mean, confronted with a High Court judgment with 7 different judgments, that analysis was just so helpful. And I think I agree with you in relation to whether or not you could possibly read into those judgments some kind of implied Aboriginal sovereignty. I agree with you. I don't think that that's really possible. I think it's counter to all of the judgments who were explicitly stating that they weren't recognising Aboriginal sovereignty, that recognition of a particular status of Aboriginal people, neither as aliens nor citizens, didn't carry with it any recognition of Aboriginal sovereignty. But we had lots of questions and thoughts about where to go from there. And I have to confess that I don't know a whole lot about this area, but all of the discussions of sovereignty, I wonder, is this a distraction? I mean, those of us who would like to see us move towards treaty more quickly, it does seem that there are a lot of obstacles in the way. So clearly the common law is not recognising any kind of Aboriginal sovereignty. So how do we go about this? I guess that the decision is saying, the High Court's decision is saying, well, it's not a matter for judges. This is a political matter. This is a matter for the government to deal with. So how does the government deal with it? do we need constitutional change? Does that have to come first? Or can we just engage in treaty making without constitutional change? And we see all of these obstacles, I think, to the idea of a coexisting sovereignty. So the common law isn't recognising that. No, where do we go from here? How do we do it? I mean, I don't know the answers to this. I'm hoping that Marcel may have some responses.
As you know, Marcel, because you referred to Kate and my report to the Premier, we certainly tried to grapple with this question in terms of the possibility of a state-based approach to treaty making. And as an international lawyer, I spent a lot of time teaching my students about the concept of sovereignty at the international level. And I certainly understand what you described as the classic sort of positivist concept of an indivisible single sovereignty. And that sort of line gets bandied about a lot in Australia as a sort of key argument against or key obstacle to treaty making with our Indigenous peoples. What's fascinating to me from an international law perspective about it is that that's never created an obstacle for Canada or for New Zealand or for the United States of America. And I did find a wonderful quotation from Michael Mansell, who Kate taught at law school, and I had the privilege of being in the same year as him. He certainly taught me a lot of things about the survival of Aboriginality in Tasmania. But he refers to no less a leading light than President George W. Bush in 2001, claiming that my administration will continue to work with tribal governments on a sovereign-to-sovereign basis. We will protect and honour tribal sovereignty and help to stimulate economic development in reservation communities. So this idea of coexisting sovereignty has never proved an impediment to any of our major allies with federal systems of government, in US and Canada's case, dealing with their First Peoples. And yes, I feel keenly the lack of treaty at the national level. I think if that happened, then the High Court would have some basis for being able to more meaningfully interact with the concept of Aboriginal sovereignty as it applied to, to people in the situation that the two plaintiffs were in. And I also think at local level, I mean, in our federal system of government, we accept that there is not one indivisible sovereign because the states have their own, their own sort of residual areas of legislative competence. We already accept that that there's a sort of interaction of sovereignties. So I think within states' own sphere of legal competence, then they must also be able to deal with relations with their own Aboriginal or Torres Strait Islander communities in terms of issues that are relevant to the jurisdiction of the state, including handback of Crown land and, whatever else might be part of a treaty at state level.
Will those state treaties be? I mean, I think that state treaties seem to be the way forward.
Yeah.
But how vulnerable will they be to sort of a
future
Commonwealth
government's
override?
Yeah, well, Commonwealth override or future state government says to hell with that.
Yeah.
I guess they'd have to. I mean, Victoria's trying to build in a dispute resolution process.
Yeah.
Precisely because of the potential for future disagreement about interpretation or application.
Yeah.
So I guess that has,
Yes.
if there's a bona fide negotiation at the state level, has to be provision for how we deal with disputes arising
Yes.
under it. But Marcel might have some own observations about that.
Yeah. And I was also interested, Marcel, in what you said about UNDRIP and the reservations you had about UNDRIP as a framework for treaties, really because UNDRIP treats treaty making as a domestic matter. And, where are the remedies? So it's not as though there's any kind of international body that can provide remedies. So I thought, that is a good thing, a good point to have made to make us think about. So there seems to be this difference between international treaties and domestic treaties, which complicates the issue.
So Joe.
Yes, yes. So finally, Sir Joe, thank you for that wonderfully entertaining presentation. I'm sure everybody enjoyed it. And I have to say, when you did the haka, Tim and I laughed. We weren't quite, I know it wasn't meant to be amusing, but it was just so beautifully done that it was just so entertaining. What a wonderful presentation.
Couldn't imagine the Banco courtroom ever being subjected to such a thing in its previous history, Sir Joe.
I think it's going to be a regular occurrence now. Whenever the Chief Justice is sitting.
All Australian magistrates and judges should hear the same message in a language they can.
I just wanted to make a little comment about what you said at the beginning of it about welcome to country and acknowledgement of countries, and how in Australia this has become ubiquitous, which it has, and also about the dangers of it really descending into just a cliche. And I thought that was most interesting. I know that when I became governor, I wanted to do an acknowledgement of country, and I was really, really worried about how I should do it and whether this was something that Aboriginal people really wanted to do. So I did ask members of the Aboriginal community what they thought, and they said yes, they really did appreciate it, the fact that when people actually did an acknowledgement of country or invited an Aboriginal person to do a welcome. But I think it's important too to try and make sure that it really is a meaningful acknowledgement of country, and that is not always easy to do. How do you incorporate it with what you're going to be talking about that day? If you possibly can, seems to me to be a good idea, rather than just saying it as though it's something you've got to say, let's do it and get over with it and then get it done with and move on to the real business. So you talking about it, saying that, you know, it really does have a deep meaning, I thought was really helpful. Was really helpful, and that is an acknowledgement, I think, that there is a prior order and prior power that I thought was helpful.
Yeah. I wasn't aware of the close relationship between New Zealand law and, well, at least the UK law in New Zealand and in the colony of New South Wales. So I really appreciated the richness of that early part of the history. The storytelling was, of course, absolutely fascinating. But for me, Sir Joe, I love the way you finished up, as well as, you know, the start that Kate's just talked about, but finishing up with the quote of the great Maori leader you were talking about, I took refuge in the law because it is a parent of the oppressed only when it's at its best. And your challenge to all of us to acknowledge that
To make it
isn't as good as it could be, and it's hard work to get it to its best. I really appreciate that exhortation, and I'm conscious in listening to all three of you, all of you representing your own First Peoples in your respective jurisdictions. As a white fella coming to the law, how much progress there is still to make. And I'm really grateful for that aspect. I think that really crosses over all three of your papers. It's a challenge to us to keep working on how we as a society embrace the First Peoples of our country. And here in Australia, we have a really massive challenge about coming to grips with the history of what actually happened here and the consequences that flow from that, understanding that it's not enough to say it happened 200 years ago, so get over it and move on, understanding that there are intergenerational consequences that flow from colonial invasion and dispossession. I think one feature of the work with Kate and travelling around the whole of Tasmania to meet with Aboriginal people all around our state was a much clearer understanding of the intergenerational consequences of colonial invasion and dispossession in this place. And I'm profoundly grateful for that and deeply challenged by it.
Yes, Joe, I did read your 2019 Cook lecture, Building a Bridge and Get Over It. And I really enjoyed that lecture, and I thought you explained wonderfully how it is that how we explain the overrepresentation of Indigenous people in our prisons in New Zealand, in Canada, and in Australia, and how you can relate all this to colonisation. And it's you explained that beautifully, and I think it's something that we need everybody to understand. You know, it's not a matter of getting over it, and it really is important to really understand the effects of colonisation and dispossession. And you explained that so well in that paper, so thank you for that too.
Let's hand back to you, Madam Chair.
Well, that's lucky. I was just about to stand up to say, not that we're getting over your commentary, but perhaps we can start. The first question I think that you were posing was a question. The two of you were posing was a question to Professor Napoleon about how, in the work that they've done in Canada, does she go about getting information in relation to the different law groups and different bodies of law and her sources. And perhaps I'll invite her to say a few words on that.
Thank you for that question. So we have the structure of the program is that the first 2 years are the dually taught courses. So I teach Gitxsan land and property law alongside Canadian property law, as I said earlier. My colleagues teach Cree constitutional law alongside Canadian constitutional law. There's Cree criminal law alongside Canadian criminal law. There's Dene and Tsilhqot'in contracts alongside common law contracts. There's Coast Salish torts alongside Canadian torts. And so those are the first 2 years. And it's the professors that create the courses. And it's a lot of work, obviously, for professors to be able to, because we don't have libraries of materials to go and draw from. So, you know, for my courses, I've drawn from interviews, I've drawn from court transcripts, I've from the Delgamuukw trial, from scholarship, and from the oral histories of that are owned by the Gitxsan, and then through the work that we do through the Indigenous Law Research Unit, the development of law reports with permission from those communities, we're able to use those as resources in our program as well. So there are multiple sources, and so Darcy, who teaches constitutional law, is Cree. His dissertation, his research, and so on, takes up different aspects of Cree governance and Cree citizenship, along with ecological governance and other things that he's worked with over the years. So each professor brings that to the courses that they teach. And then we have in the upper years, we have several things. We have administrative law and business associations. Both of those courses are multiple legal orders. It's not one or two, but it's because those subject areas are more recent. We didn't have administrative law historically as it's developed today with Indigenous governance. And so it's a field that has grown across the country with multiple cases and multiple Indigenous people. So it's taught from a multi-juridical basis, the same as business associations. So those are the upper years. We also have two they're term-long field schools, and students, we create the field schools in partnership with communities. Students have gone to the Northwest Territories in the far north in January, I want to say. They've gone to different parts of British Columbia, and the field schools, the subject matter in those field schools is determined by what the different Indigenous communities have identified as priorities. And so the students, based on the methodologies that they've learned, are able to work and develop resource materials or whatever it is that communities are wanting in partnership with those communities, and working with elders and working with leaders and so on. So for instance, one field school was on child welfare. The communities, and there are professors that accompany the students through this. So the students were divided up into teams, one team dealing with institutions, one team dealing with precedents. And so, all of these teams then had to work, through interviews, work through materials, work through all the available resources to develop this body of information and knowledge that then the community is able to use for their own governance of this area. So, it's because the students have been engaged with different kinds of methodologies with Indigenous law that they're then able to continue with the extrapolating from what they've learned to other legal orders. So I want to be clear, when students leave my property law class, they're not experts in Gitxsan law. What they know is what the governing institutions are. They know the kinship groups for ownership. They know how all of the business of land and tangible and intangible properties, they know how that works, and they can extrapolate from that to other legal orders. So that's it's the same as when students graduate with a Juris Doctor. They don't know all of Canadian law, but they have to know
Yeah,
enough.
exactly.
I'll find the answer.
Yeah, so that's the law. I hope that answers your question.
Yeah, thanks.
Can I next, before I turn to the audience and see if the audience have any questions or comments that they wish to make, just invite Marcel to comment on the proposition that you were raising in your discussion about whether states ought to be able to deal with on a treaty making basis with local Indigenous or state Indigenous groups, and what vulnerability that might have to challenge down the track.
Yeah, thank you for the question. I think we need to remember that the reason that states and territories partly went down the path of treaty making was because the former coalition government refused to entertain treaty making at the federal level. And, Ken Wyatt said this is properly a matter for the states. So Victoria actually started its treaty making process in rejection of constitutional recognition in the early days, and decided to go down that path. The Northern Territory Treaty Commissioner, who released his final report just following the federal election when Labor came to power, said that treaties should ideally be tripartite agreements between First Nations, state and territory governments, and also the federal government. And obviously there's jurisdictional issues that different levels of government can deal with, which if it's just left to the states, there's some issues that might be left out in that context. So I think there is a place for states and territories in treaty making. It makes sense in our federated system for the states to have some role in that. But I think it would be a mistake if the federal government also was not involved, because that would make the agreements more solid in terms of covering the field, in terms of the types of issues that they could address. And maybe Val could comment on that as well, coming from British Columbia, which has been undertaking a lengthy process of treaty making at that provincial level, I think you call it over there. Which is distinctly different from the historical treaties that were negotiated with First Nations during the early years of colonisation. And so that's my response to that at the moment. Yeah. Okay. Yeah.
Did you want to comment on that? Or, sorry.
There are so many different kinds of treaty animals running around Canada. We have the historic ones, which, as Marcel has mentioned, were with the federal government, the Crown, and then we've had different provinces have set up treaty commissions, and so they actually are tripartite negotiations. And some of those have been concluded, those negotiations. They've been, the problem has been that they're not on a legal order basis. They're on a small community by community basis, which has fractured the larger Indigenous societies. And so not everyone wants to go down the path of negotiating those kinds of treaties. What people have been seeking to do are declarations for recognition of title. The Haida Nation has been taking that path. The Gitineau peoples are also taking that path. And if that doesn't work, they'll litigate. So each one of those, they have pretty powerful strategies in terms of ensuring that there's space, political, legal space for their presence insofar as the province and the authorities of the province and the federal scope as well. So, but there's no one way that it's being done. It's really dependent on lots of histories.
Thank you. Thank you, Val. Now, can I call on anyone? We've got some roving mics. If anyone had Justice Baston, perhaps, and then. Is it working?
It's working now.
Yes, you can shout.
Sounds like it. It is? Okay. Tom Baston. I was taken by something you said, Val, and I'd like to just explore it for a moment. You referred to rebuilding and reconstituting a broken system. That's pretty important for us because the native title system that has evolved in this country requires that Aboriginal people establish a traditional system of law and custom. And continuity, since pre-settlement days, is an element of that. And yet we know from the history that colonization itself was inevitably disruptive and destructive. And not only did that cause change, but of course, virtually all Indigenous communities live within the present settlement of Australia. So my question is really, assuming that there is change as well as continuity, is part of your system of legality, derived from Lon Fuller's work, to look within Indigenous systems for a mechanism, I won't say a rule, but a mechanism of recognition to determine what changes are valid and what are not. And if that is so, and if we need to understand that part of the Indigenous system, then doesn't that say something about the need for a more nuanced view of sovereignty, perhaps than our court has been prepared to acknowledge so far? Thank you.
What a delicious question. So it's so rich. Part of what's important, I think, to bring into the conversation is that Indigenous peoples today, whether it's Gitxsan or Cree or Haida, we're not the same today as we were 10,000 years ago. If you look at our oral histories, there's been many moments of change where we took in other peoples. We weren't homogenous. We took in other languages. We, through time depth, and time depth is really important, lands were incorporated. So, and treaties were negotiated between Indigenous peoples. So those oral histories set out the contours of an incredible, many incredible living histories. And so when thinking about change and thinking about continuity, every generation has the responsibility to pass on how to solve problems to the next generation. There's going to be different problems, and they're going to need to apply the tools in different ways. And so if we think about law as an intergenerational conversation, and we think about that the work of law is to solve problems, then it has to be able to do that. And it has to be able to do that through time, according to the resources that people are able to bring to doing the work of law. So the continuity question, I like to think about the oral histories. The oral histories set out the covenants with the land. They set out the entire history of lineages of people and the governance and the names through which people govern. And so if those oral histories include land and how that land was obtained, and it hasn't been lost in any legal way, then the oral histories remain a record for the ownership of the land today. So what is continuing is the oral histories themselves, and how they're still recounted in the feast hall, and how there's still a record connecting the past to the present. New oral histories will be added because times have changed, but as a legal record, as precedent, the structure of the oral histories is capable of living today as it did in the past. So the structure of the oral histories is part of the continuity, not the only thing. There are many other aspects like that we can look to as providing records of continuity, as well as legal change. And actually, that's one of the next projects I'm turning to, is how legal change has occurred, not just in Canada, but in other parts of the world as well.
Yes, thank
Can I
you.
make a comment there?
Yes, certainly. And then we'll go to Justice Kuntz for a question.
I just wanted to pick up on that question because I think it is, I think it's important, and there's some experience in New Zealand about it. That's because the clash of sovereignties is, in my view, quite an arid discussion, and it's probably wrong-headed because the fact of the matter is there is law in operation. You can see it if you know where to look. The landscape in Australia, in Canada, and in New Zealand is a record of legal right and obligation, if you know it. Once you see it in operation, you realize there is law operating here and people living by it. The only question is the extent to which that is recognized within the state system and the extent to which it is legitimate and operational outside the state system. Now, in most of our countries, the state system already has some recognition of these things, usually by statute. And usually, of course, they're expressed as cultural stuff, right? Cultural connection to, I'm not talking about native title now, I'm talking about environmental, talking about control over your own people in family law, child welfare, and in criminal justice here, in sentencing, for example. And these things are often, in colonizing legal systems, referred to as mitigatory recognitions of culture, until that proposition can no longer be sustained in fact, because all of these expressions of engagement with the colonial system are law, every last one of them. Once the system makes that intuitive leap you can see organically operating sovereign systems. Of course, it doesn't have to be a clash of sovereignties. Doesn't necessarily have to be mediated by the courts, although sometimes it does, because it's actually happening. And the role of the courts that are in the process of decolonizing, and all of our courts are, in one way or another, become regulators of that discourse, whether you call it a clash of sovereignties or not, because we are talking about comparative law in cooperation. And we've been talking about that in all of our countries for a generation. Now, however, the common law courts are catching up and talking about these organically generated systems of law within the entirely common law sphere, without the support of legislation, because it's so obvious these things are in operation. And dawns on most judges that the legitimacy of the system requires us to recognize those things. Having got to that point, we're already beyond the point of no return. It doesn't matter whether we think there are competing rights of sovereignty or not, we're already in the game.
Justice Quince?
Thank you. I was struck by a coherence, at least to my mind, in the three papers. Val started to sketch out a very intriguing theoretical framework of recognition of non-state law. Marcel's paper, in a sense, I think demonstrated that why did we get 7 centrifugal judgments in the High Court? One answer may be because there is presently no generally accepted or even developed intellectual framework for looking at these questions. So the judges went off to what was really their own particular views, and that's not intended as a criticism. And then Joe's paper reminded us of what can happen when the system is in place and unexpected actors actually get to take advantage of the system because it is there and in place. My question to each of you is on the topic of authority to decide, authority to speak, really, authority to speak for those non-state legal systems. Kate Warner, I think, used exactly the right word when she talked about concessions that our system makes. And in the equity division, there are 3 that we would regularly deal with. The first is the Indigenous placement principles that apply in adoptions. The second is the intestacy adjustment under the succession laws. They are both statutory. The third is what we do in burial cases, where the law is essentially purely common law. So my question is to each of you, from your own experience in your own systems, how do you deal with this question of who has authority to speak, to instruct the traditional Anglo-Australian legal system about how to approach these questions?
And can I impose an arbitrary 1-minute limit to each of the answers so that we have room for at least one more question before the end of the session?
Part of the analysis that we do when working with a legal order on a particular area of law is, among other things, to determine who are the authoritative decision makers. For the Cree people, there are at least 4 decision-making groups. The way that decisions are made depends on whether safety is involved, depends on whether the decision needs to be persuasive or directive. So the decision-making group can be the leaders and medicine people. It can be the elders. It can be the families. And when there's something that affects the whole community, then it's the community that decides. So every society has final decision makers. So from that, you can extrapolate on how then do the folks in that society relate to authoritative decision makers in other legal orders.
Yes. Yeah, thank you for the question. I think for me, it's a matter of self-determination for First Peoples. Like if we talk about Indigenous placement principles in the context of adoptions or determining the best interests of the child, there's a huge critique about how those principles are put into practice and how they fail to represent the interests of Aboriginal people. So there's been a long call since Bringing Them Home report for self-determination in child welfare matters, so that those decisions are made by community for community, and for community to work out who is the appropriate people in those circumstances. And some research that was done up in Queensland, for example, just on kinship principles, is like when Aboriginal people had control, they could find kinship carers in 90% of cases, but when it was left to the welfare department, it was like a much lower success rate. So I think it goes back to those fundamental principles. In most cases, I would say family or elders of a particular group, and especially in intestacy and burial cases, well, it goes back to the family as well, and respected elders of that group. So it's recognising those authority structures that already exist and giving them the power to be able to make those decisions.
Can I say it's a great question, Francois? The two cases in New Zealand deal with precisely those questions, both of which got to the Supreme Court. The first one is a case called Takamore and Clark, in which there was a disagreement over where a body should be buried. And the first case in which the New Zealand Supreme Court came very close to, but did not quite say that tikanga Māori custom, is a part of the New Zealand common law. And all five judges, it wasn't a unanimous decision, but all five judges concluded that tikanga is at the very least relevant. Now, the widow, who was a white woman, won in that case, but the interesting result in the end, so this was the white widow and her children fighting the tribe over where the husband should be buried. After the widow won, the husband already buried with the tribe, and so the widow having the right by order to exhumation and relocation, there was a traditional meeting. I know because I pulled it together, in which, in order to avoid bloodshed, because there would have been bloodshed, there was agreement. And it was an extraordinary agreement done in accordance with culture for both sides. And the husband is still buried with the tribe, and the children and the widow are now closely linked with the tribe too. So it was a great example of how cultural legal practices from one side are better adapted to resolving these kinds of disputes than the Anglo-New Zealand form. So that's the first lesson to be learnt. The second is the case of Alice against the Queen, in which a man who had been found guilty of child sexual offending, probably wrongly, sought to appeal to the Supreme Court after a long gap, was granted a right to appeal but died before the appeal could be heard. Question was, should the appeal continue? We decided it should. It turned out that a central question in the continuation question was what tikanga Māori would say about this, even though young Mr. Ellis, actually not that young, was not Māori and had no connection to any Māori community. It was simply driven by the idea that not just the judges, but the council, including the Crown, all agreed that this is a matter in which the New Zealand common law should take proper account of tikanga Māori in the way that it develops. The next question was, how then do you work that out? And the Crown, bless it, called a hui, a meeting of experts in Māori law, and they produced, all the parties participated in the meeting, including an intervener who was there on behalf of the the Māori Lawyers Association, they produced a statement that was provided to the court that expressed the view of those experts about what tikanga Māori would say about continuation, and they agreed that in this case, the matter should continue, and that's the decision that we made. Now, that's a fairly elaborate process, but this was actually quite an important aspect of the New Zealand common law, and that sort of elaborate approach was supported by all. It won't usually be the case that you'll adopt that sort of process. In other areas, it'll be enough to look up the sources to get at least a general understanding of what is required. I've said this to a number of audience in the past. I know this is longer than a minute, but the judges and the lawyers in my country are being required to make a cognitive shift, a key cognitive shift, in which they will have to know enough about tikanga to know whether they've got a tikanga issue. And if they know they've got a tikanga issue, enough about it to know when they need help. And that picks up the point that was made earlier by Tim, that the New Zealand Council for Legal Education has now made the understanding of tikanga, and by that I do not mean the experience of Indigenous people in the process of colonisation, but Māori law, a compulsory subject in all law degrees, and that all the core subjects, contract, tort, crime, etc., must each of them have a component of tikanga within them. So hopefully this is to start in 2025, hopefully over the next half decade, we'll have counsel appearing in the courts who have made the cognitive shift and therefore can deal with tikanga arguments, advance them where they need to, not as questions of foreign law or as questions of fact, but as questions of local law about which alternative processes may need to be embarked upon to determine what that law is. Because there is now acceptance, and I'll stop, there is now acceptance that the New Zealand legal system is bijural, that it has two distinct sources, and the role of the court is to operate along the border.
Yes, I think we've got a question. And I know Justice Ferreris wants to have a question too. So perhaps short questions and short answers, and then we'll adjourn for lunch.
I'll be good from now on.
Look, I'll try to be brief. Pamela Tate. My question is for Marcel. It relates to the implications that can be drawn from her conclusions about Love and Tom for treaty formation, in particular the formation of a federal treaty. This touches on some of the issues that have already been mentioned. But my question is this. Is it your view that the Indigenous party to a federal treaty would be required to make an assertion of Indigenous sovereignty? And if so, is that inconsistent with the conclusions you've drawn from Love and Tom? Thank you.
Yeah, I mean, it's a very complicated question, the way you phrase it. We had a different conversation about it over morning tea. I think it's asserting, I mean, sovereignty is in many ways a Western concept. So I think it's about asserting authority for country and the right to speak for country, as we see in native title proceedings, for example. I suppose my concern as a flow-on issue from Love and Tom's is the fact that Mr. Love was not recognised as Aboriginal by the High Court. The majority agreed on the principle, but Justice Nettles wasn't satisfied on the evidence that he was an Aboriginal person. And so that matter was remitted back to the Federal Court for discussion, for further hearing. And it's still up in the air, and he's been subsequently charged and being threatened with deportation again. And he's from my mob, Gamilaroi people. So my question is like, well, you know, if we're not recognised by the High Court or not recognised as native title holders, which we're not, comparing it to Mr. Toms, who was a Gungari man and native title holder whose Aboriginality was readily accepted, can that lead us down a path where some groups will be recognised and some won't, as we see in the native title sphere? And does that have implications for treaty making going forward? Yes, I suppose to go back to your question, I think it's that authority, and certainly, Kimara people got native title in train. It's been in the courts for over 10 years, and we're uncertain where that's going to go or what that means. So, I think it's an open question for some groups, but I think it's that authority of the country that is the central issue in terms of the group identifying itself. Yeah. And I might just add that is an issue that has come up in Tasmania as well, having read Kate and Tim's report, where there has been a lot of litigation in Tasmania about whether certain people are Aboriginal, and it's been an issue that's been identified. There's a chapter in the report on the vexed question of Aboriginality, who determines who is Aboriginal for treaty making purposes. So the mob down in Tasmania are asserting their right to determine that through their own structures. And the last bit I read about that was that the former Premier had indicated they would use their existing test, which may be at odds with the community's view. It's a very complex situation down there.
Yeah, thank you. Last question, I think, Justice Reris.
Under our system of native title, the whole premise is that a people has a right to speak for a particular country. The gods gave them that language to speak to that country and to be able to communicate with the spirits of that country. And therefore, in our Native Title Act, it says you've got to, as John Baston pointed out, prove that you've had a continuous system of laws and customs that have remained in place, although they can be altered because of changes of circumstances over this period between white settlement and the present day. Now, in that context, you get evidence from people saying that young men go through the law, which is an initiation. They seem to have, as Joe Williams is saying, law that operates. But in terms of sovereignty or the like, our system recognises, and as I understand native title, it's only in respect of the land and waters which these people can speak to, and the next door people can only speak to their country. And if you come onto somebody else's country without permission, their law is it's death, because the spirits will either kill you or the human people before white settlement would. So how do you get a sovereignty outside that system? If we give native title to people, it gives them their right to that country over which they can speak and to which they can relate. And if you get exclusive possession, keep other people out. But I'm just wondering, in treaty making or sovereignty or otherwise, our law seems to recognise the authority of those traditional custodians over the land that they get title to. But how does it apply to the wider implications you've all been speaking about?
Who would like to respond? Who can respond the quickest?
So in Gitxsan society, each kinship group, each house owns a particular territory. And the oral histories that I mentioned are covenants of that ownership, along with a lot of other things. So in terms of the continuation of that, the feasts are still held today, the oral histories are still recounted today. The names that are associated with that land are part of what goes on today. These are, as Joe said earlier, these are living laws and are, continually being, people are continually upholding and fulfilling the obligations to the land in the ways that they're required to in that system. So the problem I always have with sovereignties is we didn't have a sovereign. We had decentralized authorities. So I don't want to get into that whole thing here, but we need other understandings of how to recognize authorities other than our own.
Joe, did you want to say something? Yes.
So the thing about the Anglo common law is that it's pretty much hung up on three key things. One, the idea of a central decision maker and lawmaker. Two, the idea that your relationship with the planet is encapsulated in the idea of property. And three, that your relationship with other humans in your community is encapsulated by the concept of contract. The general idea of tort comes much, much later, right? So if you talk to an alien and you wanted to explain the way those that, received the English law system, if you provided those three ideas, you'd get the basics of the law. The thing is that in these communities, those basics make no sense. That would make it not law. So, whether native title is recognized or not is irrelevant. I mean, that's whether your system recognizes property rights in land in a system that doesn't think of the relationship with the planet in that way at all. Who cares about native title, right? In terms of actual operating communities generating actual law. And anyway, there's the law in relation to their people. People inter se, which in my community is controlled and described by kinship. So the idea that you could freely relate to anybody is complete anathema, because kinship is what defines rights and obligations. And if you don't have kinship, you make it in order to establish the correct rights and obligations by intermarriage or adoption or whatever. That's my system, right? It's different to your system, but it's well and truly alive. And so native title, the idea of proof of native title can be a complete distraction from the legal phenomenon we are looking at, trying to understand and trying to make sense of. And that distraction has been created, I think, because of the monocultural approach of the Anglo system, that if you want to have a relationship with the planet, it needs to be property. And most other systems in the world would say that's bullshit.
Did you want to say?
Oh, just, very quickly. Okay. I'd just like to add to that, what native title recognises is rights and interests in lands and waters. It doesn't recognise authority over people or the system of law that gives meaning to those rights and interests. So it's very abstract in that sense, So I think it's difficult to sort of put, it's like, square pegs in round holes. It doesn't, because it dissects little bits of Aboriginal law and recognises them for particular purposes in the Western legal system. It's not looking at Aboriginal laws and customs in a holistic sense and how they relate to people and country and to other Aboriginal groups around us, international relations. So.
Thank you. Well, I'm sorry to have to bring to an end the discussion, but I know that we need to move on. It's now, I would like, however, for you to join me in thanking each of our speakers and commentators today. Professor Napoleon, who gave us great insight into what's happening in Canada in relation to the development of or understanding of prior orders and community orders in these societies there. Ms. Marcelle Burns, who told us that all roads lead to Uluru, and has a very timely presentation given what we're about to face in October. Our country cousin from Aotearoa, who gave us a fascinating example of how to conduct court proceedings with an appropriate opening in a haka. And I think that Justice Kuntz will probably be awarding a prize for the best haka rendition at the end of this conference. And our commentators in Tasmania, Professor Warner and Professor McCormack, who very generously gave us their time in order to comment on the various papers and to pose some thoughtful questions for us. I'm sorry we haven't had a chance to get back to you with further questions. You probably aren't sorry about that. Can I ask everyone to thank the speakers, and we will then adjourn for lunch.
Oh my goodness. Thank you. Thank you so much. Like,
Brilliant.
will this fit in my bag? Oh, very nice.
That's brilliant.
That's a wine glass.
Yeah, maybe I should be sipping whiskey.
this country has produced. His books included An Institutional History of the Supreme Court of New South Wales and A History of Solicitors in New South Wales. He edited A History of the New South Wales Bar. He produced a short book of portraits of the Chief Justices of New South Wales. His last major project was the publication of several volumes of the Lives of the Australian Chief Justices in colonial Australia, including volumes on the first Chief Justices in what we now call New South Wales and Tasmania, Chief Justices Forbes and Pedder. It earned him an AO on top of the many honours earlier conferred upon him. Dr. McLaughlin was a leader of the succession bar before his appointment to the bench as a Master of the Supreme Court of New South Wales. His seminal thesis on the magistrates of early colonial New South Wales can be viewed on the website of the Forbes Society. John was a regular contributor of entries to the Australian Dictionary of Biography. His broad knowledge of Australian history was enlivened in conversation about the legal profession. More than most, he knew where the bodies were buried and was happy to talk about them. John McLaughlin was a good friend to John Bennett and vice versa over many years. In John Bennett's final years, they spoke by telephone most days. A very personal final joint project of Dr. Bennett and Dr. McLaughlin was their recent posthumous publication. At their own expense, they were proud to record of a book of essays, Cases for Opinion, in celebration of our bicentenary. It is available in Abbey's Bookshop in York Street opposite the Queen Victoria building. I have a few copies that I've given to our speakers, but I don't have enough for everybody. If I did, I'd happily distribute them. My second comment for the day is to draw public attention to the 3 legal history societies operating in Australia. If you have an interest in Australian legal history, I encourage you to explore their websites and to consider joining up as a member. The work they do and the scholarship they encourage is profoundly important to an understanding of our nation. The Australian branch of the Selborne Society is administered from Brisbane in conjunction with the Library of the Supreme Court of Queensland. It produces high-quality events relating to Australian legal history and keeps us in touch with the work of the Selborne Society in England. The Selborne Society is the oldest of the legal history societies active in the common law world. The Australian and New Zealand Law and History Society connects not only Australia and New Zealand, but also international connections, especially with Canada and the United States. It has a strong membership amongst our academic community. The Francis Forbes Society for Australian Legal History was established as a bridge across all branches of the legal profession, with a mandate to promote the study of Australian legal history across the whole country, though it is administered in Sydney and supported by the local profession. We are grateful for the continued support of our Chief Justice, Andrew Bell, and before him, Tom Bathurst and Jim Spurgman, who I'm happy to see is here today. Together, as the current Vice Presidents of the Forbes Society, Mark Lunny and I represent the 2 wings of the Forbes Society. Mark has an established high reputation as an academic, well able to keep us in touch with the ANZ Law and History Society. I represent the practitioner wing of the Forbes Society. My third and final introductory comment is to pay tribute to our speakers. They have each made a real contribution to our understanding of Australian law and society. It is an honour to be on the same platform as them. In closing, I may be forgiven for making a special mention of Bruce Kircher. He was present at the birth of both the ANZ Law and History Society and the Forbes Society. He is revered by both as one of the founders of modern studies of Australian legal history. He is a consummate teacher as well as an accomplished researcher, as illustrated by the colonial law reports we know as the Kircher reports. And so thank you, Bruce. Thank you.
Thank you, Jeff. I haven't got much to say by way of introduction. I will give a commentary on the running order, but I just want to say, firstly, to endorse Lisa's acknowledgement of country, and also to say thank you to Uncle Michael West for a really powerful welcome to country earlier on this morning. I'm very grateful for the opportunity to be here today. I'm also very grateful on many fronts to Justice Williams' presentation. While my nieces and nephew have no difficulty in seeing me as an eccentric uncle, I am in fact a Queenslander, even though I spent 20 years in Anouan country near Armidale. So I was wondering how I could justify my connection to the history of this court. And then, of course, it came to me in Justice Williams' observations, as a Queenslander, we too had the Supreme Court of New South Wales until 1859. So I'm enormously grateful for that. Many of us here will have our own connections and perceptions of what the Supreme Court means. For many of you here, this will be as aspects of your professional practice, either as judges or as practitioners in this court. As I've admitted, I'm a Queenslander. I don't have that connection, but I'm a legal historian. And just perhaps two quick observations of what I think of when I think of the Supreme Court of New South Wales. And they're very episodic and anecdotal, but that's how, after all, most of us relate to the court. My work is in early 20th century private law legal history, primarily tort. And so when I think of this court, I think in terms of judicial personnel of Sir Frederick Jordan. And I'm delighted that Keith Mason is here. And I was just checking with Keith that I'd got the quote right. But anyone who's read a judgment by Sir Frederick Jordan will appreciate Keith's comment that he wrote mini lectures. These are superb summaries of the law, just as relevant today as they were, subject to some changes, but in terms of style, just as relevant as they were written in the 1930s and 40s. The second thing that strikes me about this court, in prime memory, is of course the preeminence of civil jury trial, something that we've lost, but in the first half of the 20th century was a fundamental aspect of its process. H.V. Evatt, in the first Law Council of Australia at the end of 1936, talked about, this is by the way just after there'd been a major reform of civil jury trial in the United Kingdom in the early 1930s. Evatt talked about the tough Sydney jury, which was little inclined to stray into the realm of rhetorical fancy. About the same time he made that comment, there was a case proceeding through the courts that went to the High Court of Australia, Mercer and the Commissioner of Road Transport and Tramways, a case which is still relevant for the proposition that professional practice is not of itself decisive in terms of determining whether a defendant was in breach of duty. This was a case involving a collision of two trams in central Sydney, and the issue was whether the commissioner was careless in not fitting a dead man's handle, as they were called. So if the person, for whatever reason, became disabled from operating the tram would stop. These weren't fitted on Sydney trams. They were fitted in many other tram systems of the world. The jury was asked a question, was the commissioner careless in not fitting the dead man's handle, to which they responded, yes. But a jury being a jury, they then added a rider. The jury is of the opinion that on the evidence, the accident could have been avoided had the device been fitted. They are further of the opinion that the commissioner for road transport was not careless in the ordinary meaning of the word in not fitting this device, but on the contrary, he was justified in taking the remote risk of claims for damages that might arise from accidents as a direct result. Justice Sheridan was somewhat perplexed by this rider. I'll leave you with the tantalising prospect of the conclusion by referring you to an article I wrote on this in 2017. But that flavour of jury trial, and I haven't even mentioned Hocking and Bell, which some of you may remember, 4 jury trials at the end of the 1940s before going to the High Court and a Privy Council. A very different aspect of the court, but one that is central, I think, to my memories of this court. We have a fabulous range of speakers. I'm not going to go through details of their background. You can look at them online. I want to maximise the time for them. So let me begin by asking Emeritus Professor David Barker from the Faculty of Law at UTS to commence. Thank you, David.
Thank you. Right. Could we have the first PowerPoint up, please? Thanks. I'm under very strict rules today. I've got 10 minutes and 15 slides. And also I'm suffering from a bit of inferiority complex. I have the Chief Justice of the High Court in the audience who gave the foreword to my book. I have Bruce Kircher, who was one of my supervisors for my PhD. So it's a bit of a standard to keep up. I shouldn't have complained. I didn't complain to the Chief Justice last night, but I know everybody here will put a bit of a disadvantage because it was a superb lecture last night. And we're all trying to keep up to the standard now. So what I've got to do within my 10 minutes is just briefly cover the three charters, everything leading up to the 1823 Charter. So as I've said, the origins and events leading up to the foundation of the Supreme Court of New South Wales in 1823. So the next slide is, to me, it's given this privilege of considering the effective early legislation incorporating the Charter of Justice of 1787. We've got the second Charter, 1814, and the third Charter of Justice, 1823. So what I'm hoping to do is include a review of events which led to the creation and development of legal jurisdiction in South Wales, establishment of both a judiciary and a legal profession to better assist in the administration of justice in New South Wales. So what I think is there's something fascinating, something fascinating regarding the developments when we talk about the underlying developments which led to the establishment of both court system and the subsequent legal system, former colony of New South Wales, and of course Van Diemen's Land, which, if you look back now, it's quite interesting. We're having these major celebrations, but the original centenary celebration, there was really nothing. There was scant celebration, and it was the same thing with regard to 1974. But now in 2024, next year, we hope it will be celebrated appropriately as it is now. So if we look at the early, the early years. So if you look at the early years, the first Charter of Justice of New South Wales, 1787. That's a time of settlement in New South Wales. And what's very interesting about the setting up of the very first courts is that the Crown relied on the prerogative with regard to the Charter. It was very much linked with letters patent and that type of thing. And so what we got for the very first time was a court of criminal jurisdiction. And as we're told, no presiding judge, but a judge advocate plus 6 officers of His Majesty's forces. Don't be taken in by this. The Marines always thought they were being put upon. And in fact, they objected to sitting on this court. But in fact, it was held that they had to, as members of the military, they had to do the underlying thing which the military does, which was to support the civil jurisdiction. So if we move on and we look at what was set up then, we find a court of criminal jurisdiction. There's no continuous existence of this court. In other words, it was convened by the governor as the occasion would require, and it had the authority to determine all questions of fact and law. There was no requirement to be unanimous in reaching a decision. And of course, as we heard last night, it was David Collins of the Marines, who was a deputy judge advocate. He was really a judge advocate. And in some ways, he had a conflict of interest in his role because he was both the prosecutor and he delivered judgments. It's a matter of interest. He was paid 10 shillings a day And in fact, if you think about it, he was the very first man to apply English law in Australia. If we carry on with 1787 Charter, then we have the Court of Civil Jurisdiction. And this again was established under the letters patent of the first charter. And there was a judge advocate, 2 fit and proper persons appointed by the governor. And that dealt with all civil pleas, such as land, debt, other personal pleas, personal probates and wills and intestacy. And also what we find, the development of minor courts. There was a minor courts jurisdiction to justice, similar to justices of the peace in the UK and petty sessions. And by 1800, there were justices sitting regularly at Parramatta and in the Hawkesbury district. When we have the second charter of justice, New South Wales 1814, we've got 3 new civil courts, and they replaced the civil court which had originally been set up. And that was the Supreme Court of Judicature, which is a court of justice, a judge and 2 magistrates, a governor's court, and that had civil jurisdiction, money, property in dispute not exceeding £50, and parties not to be resident in Van Diemen's Land, because the third one was a Lieutenant Governor's Court, which was set up in Van Diemen's Land, and there was a newly appointed Deputy Judge Advocate plus 2 lay members. Then we get the second Charter of Justice. The second Charter of Justice of New South Wales in 1814, following on, as I've already said, there were new rules for appellate procedure in New South Wales. Appeal to the governor had to exceed £300. If the judges and magistrates differed, then it could be taken in any cause. There were also appeals to the Privy Council, but they had to exceed £3,000 and security of a double amount. And as Bruce Kircher has stated in one of his papers, the effect of the charter was a formalisation of the law. In other words, this was a court which was given not only common law jurisdiction, but over equity matters. And then if we set the scene, we've got the early government of the colony of New South Wales. I just thought I'd just put this in perspective, because sometimes we forget about this. Australia settled by Europeans in 1788. 1786 proclaimed a crown colony. We had Captain Arthur Phillip. 1806, Captain Robert Hunter. 1800, Captain Philip King as governor. 1806. 1806 is very important because that was when William Bligh was created as governor. And of course, we had the Rum Rebellion. And I would say to anybody that in my paper, you'll find there's a very interesting book which has been written, how rum really greatly affected what took place in New South Wales. And as we know, that in 1808, MacArthur and Johnson took over from William Bligh. And in fact, William Bligh never went back. Well, he went back to England after about a year. He went down to Van Diemen's Land. And although Johnson and his colleague MacArthur both went to be tried in England, in the end they came back and they were both successfully carried on in enterprises in New South Wales. So also, if we set the scene with the early legal participants, as we were told last night, political divide between the exclusive and the emancipists. And so one of the problems was, of course, that in 1810, there were only 3 former convict lawyers. And of course, this created a problem when Geoffrey Bent came, because he refused to recognise, and there was a standoff between him and Macquarie. And of course, the court was closed until 1816, and then in 1816, in December the 11th, Justice Bent was dismissed by Lord Bathurst. who was the colonial secretary at that time. If we look at the third Charter of Justice of New South Wales, that's 1823, that's the main one. We've already had Thomas Biggs' report on the need to change the court system. And so the Act of 1823 abolished the Court of Criminal Jurisdiction and the Supreme Court. There was a complete break with the past. And this incorporated, if anybody remembers their English legal history, this incorporated the reforms of the English Judicature Acts 1873-75. If you remember, that's when equity, administration of equity and common law were merged. And also it provided circuit courts and equitable jurisdiction. Slide 12, carrying on with the third charter, of New South Wales, we get ecclesiastical law coming in, delegated authority for ecclesiastical law, and the courts could deal with wills, administration of estates, property, guardianship of infants, insolvency, and for the very first time, admiralty matters. By that time, but of course there was this real dispute about whether or not there should be juries. And of course, the English administrators were very concerned that, of course, juries where there were ex-convicts might be influenced in some way or other. So you didn't get juries in New South Wales. What you got was 7 commissioned officers of the armed services. They acted as the jury. We still had civil cases, and there were questions of fact, and we had a chief judge and 2 JPs who acted as assessors. If we move on then to slide 13, which is the third Charter of Justice continuing, and then we get the introduction of ministerial officers of the court, registrar, notary, master, keeper of records, and sheriffs for the first time. We have sheriffs who could execute the court process and escort prisoners. That was a new introduction. No fundamental changes regard to appeals, except that they were just the limit was reduced to $2,000 if it was going to go to the Privy Council. For the slide 14, the third Charter of Justice, we carry on. We had inferior courts. The 1823 legislation brought a structure of inferior courts into New South Wales more in line with English courts. We had criminal jurisdiction, general or court of sessions, and we had civil jurisdiction, a court of requests, and that was civil suits less than £10. And if you look at there, we had courts of inferior criminal jurisdiction, courts of petty justice. To finish with slide 15, we had what I would say to you now, what I would like to refer you to my paper, which I hope is much more helpful because you can read it at leisure. You'll find that what I try and focus on is the influence of English on Australian law and early New South Wales judiciary system. Alec Castle stated, principles of British constitutional law were foundation of the legal system of Australia. He was supported by Chief Justice Francis Forbes, but J.M. Bennett differed. He said at common law, Westminster paternity was plain, but in other respects, Supreme Court was different from English tribunals as one could imagine. And what I would say to you is, in celebrating the bicentenary of the Supreme Court of New South Wales, appropriately recognise both the characteristics of the English law, which has affected the development of the Australian judicial system, but also the distinctiveness of the Australian law, which has developed over the period since 1788. Thank you very much.
Thanks very much, David. The format will be, we will have 2 sets of 3 speakers with some questions at the end of the first 3 speakers. So with that in mind, may I invite Emeritus Professor Bruce Kershaw to make his presentation, who I think is in the wings.
Where I am.
Great, thanks, Bruce.
Thank you. Tēnā koutou, kia ora. I want to build on David's paper and to talk about judicial decision-making in early New South Wales. In the written paper, I contrast the judicial styles of the three periods of courts that David has described under the first, second and third Charters of Justice. Here, given the time available, I'll just restrict myself to the third period when Sir Francis Forbes sat in the new Supreme Court as Chief Justice, and then only for his years, 1824 to 1836. What kinds of judgments did he and his puisne judges deliver? And I'll try to answer that by reference to just a few cases, particularly on the reception of law, because I think it says more about the style of judicial making than any other kind of case. Now, this is all a bit trite for this audience, but as we know, not all of the laws of England were automatically adopted in the colony. There were two major questions. What was the date of reception of English law, which applied to statute law, not common law? And secondly, for the statutes passed before that date, what were the principles of selection by which some laws were received and others not? Forbes discussed both of these questions in a case called the Crown against Broadbear in 1826. He held that the date of reception wasn't the conventional date of the establishment of the colony, but the later date of the commencement of its legislature. The later date would have allowed the reception of some of the capital punishment abolition statutes which were regularly being passed in London at that time. In Broadbear, Forbes followed Blackson's famous statement and considered whether the law in question was applicable to the condition of an infant colony. In effect, that's the common law provision on the reception of English law. This raised two issues: whether the colony had the machinery required for the operation of the Act, and the broader question of its suitability to the colony's conditions. Fortunately, for the development of the new court's jurisprudence, James Dowling in 1827 and William Burton in 1832 were appointed as puisne judges. Burton was as articulate as the two, as Forbes and Dowling, but he had a very different attitude to major legal issues, as I'm about to say. And this resulted in rich, well-argued judgments from a variety of viewpoints. It's the quality of the judgments I'm trying to emphasise. The clearest example of the clash of views was a case called MacDonald and Levy in 1833, my favourite case. By this time, there was a new date of reception, July 1828, under Section 24 of the Imperial Australian Courts Act. The point in issue in this case was the adoption in New South Wales of the English usury laws, whether they were enforced. The assumption in the colony had always been that those English restrictions on interest rates didn't apply. Was that evidence that the English usury laws didn't apply in the colony, that a local custom had developed, or was it just proof of long-term law breaking? The majority held that English usury laws were not enforced. Characteristically, Justice Burton was the person in dissent, the judge in dissent. There could be no colonial custom, he held, because custom required to have been in operation since time immemorial and to have been uniformly maintained. Neither of those requirements was satisfied, he held. He developed this view by reference to the general history of the colonial possession of the Crown and the legal history of New South Wales. That's the things I want to emphasise. All three of these judges constantly refer to legal history. Burton adopted a strict interpretation of the 1828 statute. He decided that it did more than impose a new date of reception. It also provided a new reception test. The key phrase for him was that Section 24 stated that English law was to be enforced, quote, so far as the same can be applied. In his view, that was merely a mechanical test. Can the law be applied? It's not a question of expedience or convenience, he found, and he found that in a number of judgments. It didn't matter whether this had an adverse effect in the colony. Privately, Burton seethed with anger about the state of the law and commerce in the colony. He told friends that the court showed a disregard to legal principles and a capricious adoption of some English statutes and the libertine abandonment of others. His judicial language, as we've seen, is much more restrained. In majority with Dowling, the Chief Justice Forbes decided that English usury law did not apply in New South Wales. Forbes said that interpreting Section 24 as his brother Dowling did was a misconstruction. Section 24 wasn't a new principle. Instead, it was affirmative of the law as it had stood before. After citing Blackstone again, Forbes decided that New South Wales had a usage of higher interest rates than English laws allowed. The usage wasn't a custom, but a non-user. As a result, the English statute was wholly inapplicable in New South Wales. While English law was the colony's birthright, Forbes said, it had to be applied with care. Returning to the quality of the judgments, I think McDonald and Levy is a great foundation of the Supreme Court's methods. It was clearly argued by all three judges, based on rich references to the legal history of the colony and the empire generally. It showed two tests for the application of English law and two attitudes to the flexibility of legal principles. Was the colony's law strictly English, or could a flexible allowance be made for different circumstances? Would statutes in future be interpreted literally by their terms, can be applied, or would interpretation be based on the apparent purpose of the legislators? As we all know, that contrasting view has continued pretty much ever since. These questions, were continued to be raised ever since. Sitting together in what was still little more than a frontier town, these three judges provided what I think is a brilliant basis for the court's future work. Their judgments were comprehensible to an educated lay readership. They were reported in the local newspapers, and they're likely to have been convincing to members of the legal profession. Reception of law cases were in question right up to Forbes' last day on the bench in 1836. On that day, the court decided the Crown against Maloney, a bigamy case. In question was whether English marriage law was in force in the colony. By the same majority, Forbes and Dowling declared that it was not. Once again, Justice Burton dissented, and that would have resulted in all Catholic marriages being void and all children of those marriages illegitimate. That was also the day, Forbes' last day on the bench, in which the court declared judgment in the profoundly important case of the Crown against Murrell and Bummery. This too could have resulted in a split court, but Forbes and Dowling this time agreed with Burton. In question was whether a violent conflict between Aborigines was subject to the jurisdiction of the colonial courts. It had long been accepted that the courts had jurisdiction when a settler attacked an Aborigine or the reverse. However, in interstate matters, as they were sometimes called, as of clashes between Aborigines, there was more doubt. In the earlier case of Ballard in 1829, Forbes and Dowling seem to have agreed that the court had no jurisdiction in matters of conflict solely among Aborigines. They appeared then to show a willingness to recognise Aboriginal laws. When the court considered the matter in Murrell, both Forbes and Dowling changed their minds. Murrell was reported by Legg and fell within the category of received law until its basic premises were reconsidered and overturned, of course, in Mabo No. 2. Ballard was forgotten. The leading judgment in Murrell was written by the determinedly English Justice Burton. His famous judgment declared that although Aborigines were a free and independent people, they were of insufficient numbers and civilisation to be entitled to recognition as sovereign states governed by laws of their own. By discovery, occupation and legislation, the laws of England were applicable in New South Wales, said Burton. But characteristically, Burton declared that any possible, quote, difficulties and inconveniences and hardships arising from this decision were much overrated. In his judgment, Forbes declared that in Ballard's case, no opinion had been given as to their jurisdiction. That's not the impression that newspaper readers might have gained on reading the report of that earlier decision. Forbes seems to have had a drastic change of opinion. He was very ill at the time, which forced his return to London. Having written a strong opinion against the views of Burton on the marriage case on that day, had he run out of energy to do the same in Murrell? The establishment of the Supreme Court of New South Wales does serve commemoration 200 years later. Its first judges and the legal profession which supported them brought a quality which had been lacking in the 36 years since 1788. As we've seen, that quality was particularly evident in the reception of law cases. There were dozens of them while Forbes was on the bench. In reflecting on these judgments, of course, we should be aware of the nature of English law in the early 19th century. Slavery still existed in some colonies. English law, as we heard this morning, was still hideously cruel towards Indigenous people, was also cruel towards British children and wives and Roman Catholics, debtors and those convicted of even minor crimes. The Supreme Court's judgments showed judicial resistance to some of these cruelties, particularly those in the hands of Francis Forbes. The cases I've written all mentioned contained richly professional judgments. Of course, there's no unanimity among them, but what they had in common was the quality of their explanations. They carefully analysed the words of statutes, though in different ways. They made extensive use of decided cases, but not through a process analogous to statutory construction. Instead, their concerns were with underlying common law and equitable principles. One final point is that it's clear from these cases that Sir Francis Forbes was Australia's first significant legal historian. Like Dowling and Burton, he often considered the colony's legal practices which had taken place in the past, such as the high interest rates which had been allowed. In these cases, we can see history written by judges at a time when memories of the early days of the colony were still alive. Forbes, however, took an important step beyond those his two brother judges. When considering the meaning and applicability of statutes, he took two steps. First, he looked at the history of the law as it was immediately before the statute was passed. From that, he said, he could understand the purpose of the statute and the words which it used. That was his distinctive contribution, one which is based in legal history.
Thank you. So, thanks very much, Bruce. The next and final paper in the first session will be delivered by Malcolm Shivens, the President of the Tasmanian Civil and Administrative Tribunal, presenting on behalf of Chief Justice Blow.
Thank you. Good afternoon, and I'd obviously also like to thank Uncle Michael for the welcome earlier today. Just in case some people here weren't at Government House last night, unfortunately, Chief Justice Blow has an injury which has prevented him from travelling here today, and as I know he wanted to. So if you could all just pretend I'm about a foot higher and have a much more authoritative voice, this will go quite well. The Sydney Morning Herald started out in 1831 as a weekly newspaper named the Sydney Herald. On page 1 of its first issue, there was a report of Governor Darling sending to England for the King's approval some regulations that had been made by the Supreme Court of New South Wales, dividing the colony's legal profession into two branches: barristers with a right of audience in the court and solicitors or attorneys with no such right of audience. When the Supreme Courts of New South Wales and Van Diemen's Land commenced to sit in 1824, the fledgling legal professions in Sydney and Hobart were not divided professions. There were no restrictions in place as to what sorts of work barristers, solicitors, attorneys, proctors or others were or were not permitted to undertake. That changed in New South Wales in the 1830s, and New South Wales has had a divided profession ever since. However, no such change occurred in Van Diemen's Land, and Tasmania continues to have a fused profession. The background to the division of the profession in New South Wales has been set out very thoroughly in a number of publications, including as those by J.M. Bennett. I should say for those Tasmanians viewing today, the Chief Justice asked me to point out that's not John Bennett, otherwise the former Attorney General of Tasmania, who was neither a historian or an academic. The ancient usage whereby only members of the bar would be heard in superior courts at Westminster was not a rule of law for the colonies. Rules as to admissions and rights of audience were made on a colony-by-colony basis. The 1823 Charter of Justice under the Supreme Court of New South Wales was established, contained in Clause 10, a provision authorising and empowering the new court to approve, admit and enrol barristers, advocates, writers, attorneys, solicitors and proctors who'd been admitted in Great Britain or Ireland and authorising those persons to appear and plead and act for any suitor of the said court. Clause 10 also prohibited other persons from appearing, pleading or acting in the new court and authorised the court to admit additional persons as barristers, advocates, attorneys and solicitors, but only if there was an insufficient number of such professionals in the colony. In September 1824, two men who'd been admitted to the bar in England, Robert Wardell and William Charles Wentworth, one in the same, who found the route across the Blue Mountains with Blaxland and Lawson, and perhaps lesser known, won the first official horse race on Australian soil on the horse named Gig, were admitted as barristers in the Supreme Court of New South Wales and immediately sought an order that the attorneys and solicitors then practising in Sydney retire from the bar. They argued to the effect that, on a proper interpretation of the 1823 Charter of Justice, solicitors and attorneys had no right of audience. At that stage, there are only 10 lawyers practising in New South Wales: the Attorney General, the Solicitor General, Wardell, Wentworth, and 6 attorneys and solicitors. Chief Justice Forbes gave judgment against Wardell and Wentworth, holding that the Charter could not bear the construction that they had sought to put upon it. However, he said that he hoped that in time a separation of the profession in the two branches would be accomplished. An opportunity to divide the legal professions of the two colonies arose as a result of the passage of the Australian Courts Act 1828. Section 10 of that Act empowered the judges of each of our two courts to make rules for various matters, including the admission of attorneys, solicitors and barristers. In March 1829, a proposed rule dividing the profession into two branches was read out in the Supreme Court of New South Wales. The provisions of the proposed rule were debated in the full court on 1 June 1829. In a reserved decision on 5 September 1829, the court announced that the profession was to be divided, provided that the rule would not take effect until His Majesty's pleasure shall first be made known. Those then practising were allowed to choose which branch of the profession they would practice in. No other persons were to be admitted as barristers unless they'd been admitted as advocates or barristers in one of the King's courts in Great Britain or Ireland. Various qualifications for admission as solicitors or attorneys were also provided for. As a general rule, regulations made in the colony became effective without royal approval, but were subject to disallowance at His Majesty's pleasure. However, the rules relating to the status of members of the legal profession were not to take effect until His Majesty's pleasure had become known, because of the impact that commencement and subsequent disallowance could have on members of the profession. By 1831, concerns existed as to whether the rules made on 5 September 1829 had in fact ever been sent to England for His Majesty's approval. It appears that nobody knew whether they'd been sent or not. Governor Darling therefore sent those rules and certain others to the King in 1831 and publicly announced that he'd done so. The report in the first issue of the Sydney Herald was not a stale news report of the making of the rules, but a report of the action taken by the Governor. On 1 November 1834, after a delay of 5 years, Chief Justice Forbes informed the bar that His Majesty's pleasure had become known and that the rules dividing the profession were now in force. There were angry scenes. A number of attorneys and solicitors had assumed that nothing would ever happen and therefore had failed to elect to practice as barristers and had lost the opportunity to do so. The result is that ever since 1 November 1834, New South Wales has had a divided legal profession. So the situation in Tasmania. In 1823, the Charter of Justice for Van Diemen's Land contained the same provisions as to the admission of barristers and others as the 1823 Charter for New South Wales. However, there was no move to divide Tasmania's legal profession. Some barristers were admitted to practice in the Supreme Court, but unlike Wardell and Wentworth, none of them appear to have taken any step towards the reduction of the rights of status of other admitted members of the profession. In 1831, pursuant to a provision in the Australian Courts Act, Van Diemen's Land was granted a second Charter of Justice. It explicitly provided for a fused legal profession. It provided for persons who had been admitted in various capacities to the superior courts in Great Britain and Ireland to be admitted and enrolled and to act as well in the characters of barristers and advocates as of proctors, attorneys and solicitors. Although the Supreme Court of Van Diemen's Land was never expressly authorised to admit barristers to practice solely as barristers, it sometimes did so. A new roll of practitioners was commenced in 1831 and is recorded in that roll from time to time that individuals were admitted simply as barristers, whilst most were admitted as barristers, attorneys, solicitors and proctors. In 1840, the Legislative Council of Van Diemen's Land passed the first statute relating to the admission of practitioners. Section 3 of that Act made provision for certain individuals to be eligible for admission to practice as barristers, attorneys, solicitors and proctors. No legislation has ever been introduced in Tasmania to prevent solicitors from practising as barristers, but from 1863 onwards, there have been provisions for individuals to be admitted to practice solely as barristers. There have also been arrangements for individuals after admission to practice as barristers and solicitors to elect to practice solely as barristers. The Barristers and Attorneys Admissions Act 1863 contained a provision in Section 4 which authorised the court to admit individuals as barristers only. They were required to pass an examination in general literature and in law and to have resided in the colony for 12 months before admission, but they were not required to have worked as article clerks. A similar provision was contained in the Barristers and Attorneys Act 1874. However, no such provision was contained in the Legal Practitioners Act 1888. From 1888 until 1952, the court was empowered to admit persons only as practitioners, and a practitioner was defined to mean a person admitted to practice as a barrister, attorney, solicitor or proctor. Moving into 1952, the 1898 Act was amended to provide for interstate barristers to practice in Tasmania as barristers. Similar provisions were contained in the Legal Practitioners Act 1959 and the Legal Profession Act 1993. It became common for interstate barristers, particularly Melbourne Silks, to get admitted in Tasmania and appear in important civil cases. In 1962, the 1959 Act was amended to introduce a system of fidelity bonds. As a general rule, firms and sole practitioners were required to obtain fidelity bonds, but the new provisions did not apply to any practitioner who professes to practice only as a barrister and does not so practice. From then on, there were a number of practitioners who held annual practicing certificates, but were exempted from the fidelity bond requirements because they notified the Law Society of Tasmania that they were practicing only as barristers. Most of them were politicians and academics who were hardly practicing at all, but from time to time a number of practitioners who had the right to practice as both barristers and solicitors practiced as barristers only and did so on a full-time basis. In 1972, the Law Society of Tasmania made some rules entitled the Barristers' Rules of Practice. Under those rules, a practitioner who proposed to practice exclusively as a barrister was required to first cause his or her name to be placed on a practicing list kept by the Secretary of the Society. The rules contain various provisions that one would expect, including a cab rank rule and a rule prohibiting barristers from soliciting business. Previously, Tasmania had no written rules as to the conduct of barristers. A number of Tasmanian practitioners were appointed as King's Counsel and subsequently Queen's Counsel between 1950 and 1998. Before each appointment, the appointee gave undertakings to the Chief Justice that he, they were all male, would practice only as a barrister and would abide by the conventions applicable to His or Her Majesty's Council. It was not until 1983 that a group of barristers commenced to share chambers together for the first time in Hobart. They occupied part of a building named Treasury Chambers. It had been given that name by its original occupant, a company that carried on business as a wholesaler of wine and spirits. The members of those chambers moved out in 1991, going to a building in Battery Point that was originally a malt house and established malt house chambers. There's a theme in those buildings. There are now several sets of barristers' chambers in Hobart, as well as a number of barristers practicing in the north of the state. Since 1983, Tasmania, like the other Australian jurisdictions with fused professions, has had a recognisable separate bar. The Tasmanian Independent Bar, as it was then known, was represented for the first time in the Australian Bar Association in 1995. The Tasmanian Bar Association Incorporated is now also a constituent body of the Law Council of Australia. The arguments about the desirability of or undesirability of divided or fused professions are beyond the scope of the Chief Justice's paper. However, it's worth mentioning that the late Campbell McComas once addressed that subject while masquerading as the President of the Law Society of England and Wales. He told the audience that a man who cannot afford the services of a barrister should always take special care to ensure that he never needs one. Thank you.
Well, thanks very much, Malcolm Vicarissi, on behalf of Chief Justice Blow. We now have time for about 10 minutes of questions. If we have any time at the end and we don't get through all the questions from this session, we can come back to it. But I invite the audience to ask our panel members any questions, comments.
Well, I'll ask, do we know how they got by without the sorts of law books that we have? In those days, a lot of law was in what we would recognise more as a digest rather than a modern textbook. Given the distance between England and here and the difficulty of carrying law books, how did they cope? And bear in mind also that the law reports that we know didn't start in any real way until the 1860s or thereabouts. So if somebody could answer those questions, I'd be grateful.
At the time of, at the time of the bicentenary of 1788, I think it was the National Library of Australia, or maybe it was in New South Wales, put on an exhibition of the law books which had been carried on the First Fleet, not the actual books, but among them. So they had the Statutes of England. Most importantly, they had the 4 volumes of Blackstone. There's this great belief in I've been talking to people in the United States about just this question, about the convenience of Blackstone, the American editions of Blackstone. There were 4 volumes, 2 went in each saddlebag, and off you went. You rode across the plains carrying Blackstone, 2 in each saddlebag, and you delivered the law. I don't think we can underestimate how important Blackstone was, actually. Of course, there were cases as well. Burton refers to case law a lot, but I don't think it all comes from Blackstone.
Can I follow up a little? Can everybody hear me? So also the problem with these criminal cases, criminal law changes that are happening in England under Peel's great consolidation of criminal law, is that they're arriving a little late. So that process of trying to figure out whether law had been received was sometimes real time. So in the late 1820s, the court had a series of very private crises that didn't make it into the courtroom because it would have been terribly controversial, because they had actually hanged some people, hadn't they, after some of those crimes had been made non-capital. So the problem of when they came, Jeff, is actually incredibly salient and caused a lot of trouble in the 1820s.
Yes.
Other questions? I have some, but I'd like to defer to the audience if anyone has one. No?
Well, can I ask this question? Dowling, the second Chief Justice, was a great reporter of recorder of cases, which were ultimately published. But were they publicly available at the time, or only when did his reports, the Dowling reports, actually become shared or public?
I think that Tim, this century, or last century. Bruce.
Yes, it's interesting. When Tim Castles and I did the Dowling reports, we found them in manuscript form. He was preparing for them, but they were never published. So we thought it was a bit romantic that we published them so much later. But the really significant thing, I think, is the newspapers in New South Wales. Beginning from the time of the Sydney Gazette Foundation in about 1806, 1807, whenever that began, there were law reports. Now, what I didn't say today that's in my paper is that we didn't really begin to get judgments until 1817 when Baron Field was judged. Before then, what the doings of the courts were the major business of the newspapers. When formal reports began to come in 1817 with Baron Field, formal judgments, I should say, began with under Baron Field, the newspapers reported them verbatim. They're extraordinary sources. By the time Forbes left in 1836, left Sydney in 1836, there were, I think, 4 newspapers, each reporting the same decisions in the court and reporting the law faithfully. That's our principal source. We go to the archival record when they exist, look at the judges' notebooks, and they reinforce what the newspapers have said. If you look at Legg's reports, which were published in the 1890s, they were based on newspaper reports. He said in the introduction that he had checked them against the archives, but it's the newspapers is the answer to your question, I think.
I'd like to, perhaps this is a question for Malcolm, but also perhaps for the general audience. Is the fixation with separating the professions one really of status as opposed to anything practical? Because as I understand it, rights of audience weren't linked to which branch of the profession you were in, at least in theory.
Look, this is not a direct answer. I can remember, so whilst I'm born and bred Tasmanian, I came to New South Wales about 13 years ago before going back to Tasmania. And I remember in one of the first weeks I was here, someone asked me if I was a barrister or a solicitor, and I said both, which was greeted with horror and a strange look. So that was the first time I actually had to bother looking at the difference. I think in the Tasmanian context, and also have to bear in mind, the Chief Justice would know this definitely, I think there is probably less than 30 people practicing exclusively at the bar in Tasmania. And even then, many of them would practice in both Tasmania and Melbourne and perhaps Sydney. I wouldn't have thought it's a matter of status. It's more the nature of, a colleague of mine said it's competing. It's competing with those professions now that we have a much greater movement across states of practitioners where there's an expectation of clients. I suppose in a way this is status, where they would get a silk, etc. from Melbourne or Sydney in certain matters, where they will look to do so in Tasmania. But having said that, I know that still very significant matters in Tasmania, you will have people who would call themselves solicitors appearing.
My recollection, which may not be accurate, is that in England, solicitors did not have a right of audience. Here in New South Wales, I think it was about 1895, they changed that. So from that time, solicitors did have a right of audience.
Just for Bruce, I was struck by the reference to Blackstone. I've always been puzzled why referring to Blackstone is so much more deeply ingrained in the US DNA than it seems to be in ours. I mean, you can read US Supreme Court judgments of today and they still cite Blackstone. Do you think, was it as popular in the early days of the Australian legal system? And if not, why not?
That's a wonderful question. I don't know the answer to it. I'm sorry. Was it as popular? There are, if you look at, for instance, you look at the notes of Justice Burton, when he wrote the Murrell judgment, he provided two versions. One was a quite shortened version, and the other one was a very, very extensive version, which is in the archives. And he put at the top, this is in case I have to deliver this in dissent. He'd be much more thorough if he had delivered it in dissent. When you look through the...
Oh, no.
As I said earlier, there are lots of references to decided cases and to the great figures of international law, what was then called international law. I don't know the answer to your question, I'm sorry. There's not a lot in the judges' notebooks that I've looked at, not a lot of direct reference to Blackstone, some, but not a lot. Well, as I said, Francis Forbes referred to it in the Reception of Law Principles. So I'm sorry, I don't know the answer to the question.
Mark, can I just jump in?
Yeah, please.
Just a tiny bit of US history. Oh dear. All right, so the US was state building at that moment, right? So they just had the revolution. There was this incredible outpouring of efforts to decide which laws to keep. So that reception of law issue articulated in the context of the post-colonial emergence of the American state. So they were looking to English sources, deciding what to keep, what matters. So I'd imagine that Blackstone had a much more important role there than it did in exactly the same moment in New South Wales when they didn't even have lawyers running the court.
Yeah, just on that, I think it's interesting that, I think in the US, Blackstone's more significant in a public law context. So I remember in Armidale, one of the oldest firms was getting rid of its library about 15 or 20 years ago, went back to the 1870s, and they had the earliest books was a American edition of Blackstone from the 1860s, and Wilfar Press has written on Blackstone in Australia as well. So I think it has influence. I just think, as Lisa points out, it's probably a different context. Blackstone's incredibly influential in Australia, but not perhaps for the same reasons, because it's not the constitutional reasons that are important in the US are not quite so important here, I think. But it's really important resource, Bruce says. Yes, Keith. Well,
So I think about 15 or 20 years ago, the US Supreme Court had a culture war on whether it was appropriate to cite case law outside of the American system that was part of, well, associated with an attack on the death penalty as a cruel and unusual punishment. And Scalia boasted that he had never cited any English case law after 1776, but he quoted many pre-1776.
I heard him in a debate with Breyer where he said, I quote more foreign judgments than any other judge of this court, and gave that example.
Yes.
thank you. We might then turn to our next set of three speakers, and may I ask Professor Lisa Ford to deliver her paper.
Thanks, everyone. And thanks so much, Alan and team, for putting this event together and inviting me along to speak to you all. It's a great honour. So yesterday, the Chief Justice and today, David, both together, they've both given us an admirable outline of the progression towards the first Supreme Court of New South Wales. As we have heard, the court, along with the colony's first legislative council, was the centrepiece of the 1823 New South Wales Act. Leaving some details to the King and Council, the Act actually created, it gave remarkable details about the first fully professionally staffed and properly constituted judicial body ever to grace the colony. It proved the most enduring institution established by the Act, indeed. Bruce has followed up with an ode to the professionalism of the first court, particularly on those incredibly important questions of reception. And Chief Justice Blow, ventriloquised admirably by Malcolm, has talked about the division of the profession in New South Wales and perhaps the much more sensible refusal to divide the profession in Tasmania. But my task today has been to invite you to step back and view the establishment of the Supreme Court of New South Wales in its imperial perspective. And let's see if this works. You made me really nervous about this. All right.
Yeah, it's working.
Thank you. First, let me put the colony of New South Wales itself in its imperial perspective. The colony was an extremely autocratic place from 1788, really until the advent of the first partially elected government in 1843. We often assume that this was so because it was a convict colony, an open-air prison for the refuse of the British Empire. This is true, but it's only part of the story. In fact, New South Wales's early constitution was also the product of a wider constitutional project undertaken by the British Crown with the help of Parliament to stem the tide of the Age of Revolutions. New South Wales was set up just 5 years after the American Revolution ended, indeed partly because convicts could no longer be sent to America. The colony was given a governor, a naval officer with no council, and expansive but imperfect power to rule. As we've heard, it was also given a truncated quasi-military court, headed by a judge advocate. Was this exceptional? Kind of. A little bit. To some degree, New South Wales's autocratic government followed a new pattern of constitution making that had started not long before. Oh, I don't know where he came. Oh, yeah, that's right. He does belong here. So, not long before, in 1773, the Regulating Act, Parliament first established pro-consular rule by a governor without legislature. I actually do think we need this next slide, in the East India Company holdings in South Asia. A year later, in 1774, and very controversially, it imposed a similar structure on the conquered colony of Quebec. Quebec was the first colony in North America or the Caribbean not to be given an elected legislature. Indeed, this was one of the law reforms that precipitated the American Revolution. our little government in New South Wales was less carefully constituted than its forebears in 1787. Our governor had more power and less accountability than elsewhere. Yet, curiously and importantly, as the Chief Justice pointed out yesterday, no clear power to legislate. However, our court structure was peculiar indeed, a strange hybrid of military jurisdiction and simplified common law, and over which the governor exercised remarkable and usually unhelpful influence. But overall, our open-air prison was odd, but not so exceptional. Indeed, in the 1820s, when it passed the New South Wales Act, the Imperial Crown set about bringing the colony into line with the structure of government that had prevailed in Quebec until 1791, and that still prevailed in India, though New South Wales was given a much smaller and more exclusive legislative council than either. We historians like to say, and here we'll go back to this bloke, we like to say that the transformation of the Constitution of New South Wales started with John Thomas Biggs' inquiry into the state, administration of justice and finances of the colony, launched in 1819. However, our Legislative Council was actually much smaller and less representative than the council structure that the notoriously snobbish Bigg recommended. So the Legislative Council established in 1823 was no great leap towards self-government, but it did start a new moment of constitutional reform across the empire. But these are points I'll belabour much more when I talk to the conference to commemorate the bicentenary of the legislature later this year. So now to the business at hand. Our first Supreme Court is a little bit more interesting in the context of the constitutional history of the empire. This is so because in the 1820s, our Act and our court played a larger, if still ambiguous, role in pan-imperial constitutional reform. Again, as the Chief Justice pointed out, Commissioner Biggs' inquiry into the administration of justice in New South Wales had surprisingly little impact on the court actually established in 1823. He recommended that separate courts be established for New South Wales and Van Diemen's Land, to be sure, but with only one trained judge for each, assisted by officers in the criminal jurisdiction and magistrates in the civil. In this regard, his recommendations were more minimal than the suggestions of either of the serving judicial officers in New South Wales at the time. Both wanted properly staffed courts with more extensive jurisdiction, and all were outdone by the model of the court we actually received. Again, the most obvious model for our Supreme Court was the court established for the Indian presidencies under the Regulatory Act and the Charters of Justice that followed. Letters patent issued by George III on March 1774 established a Supreme Court of Judicature, exercising criminal, civil, ecclesiastical, admiralty and equity jurisdiction in all matters pertaining to British subjects and company servants in the three presidencies of India, and exercising more limited territorial jurisdiction in Bengal, Bihar and Orissa. The first court's efforts, under Chief Justice Impey here, to expand its jurisdiction to protect Indians from company misrule precipitated a series of crises that culminated in the 1781 Judicature Act, which radically truncated the reach of the court. However, the most important immediate context for our court was the effort in the early 1820s to survey and reform imperial law across the whole British Empire. Even before the New South Wales Act was drafted, but after Bigg had returned to London, Supreme Courts like ours were part of a broader 1820s conversation about the reform of colonial justice. In 1822, for example, commissioners of legal inquiries sent to the Caribbean were asked to consider the suitability of a quirky but very similarly structured Supreme Court for the Leeward and Windward Islands in the Caribbean, which I believe I have a map, but you probably can't see. These proposals came from an anti-slavery advocate, George Nugent Grenville, eager to enhance Crown control of West Indian justice. Now, Google could not provide me with a picture of Lord Nugent, but his parliamentary biography pointed out that Nugent was even fatter than his brother, but not remotely so obnoxious. He had a very pretty wife, though. I did find a picture of her. It was supported by Okay, so this change in the West Indies, or this proposal, was supported by creditors who were sick of being cheated by untrained and debt-mired planter judges. Lord Nugent proposed a single circuit Supreme Court for each of the island clusters, consisting of a Chief Justice, a puisne judge, and a third judge who would reside in each subordinate colony where he would lead the local judiciary. This model was endorsed by the commissioners in a series of letters and reports sent home between 1823 and 1830, and was actually legislated by Parliament only in the late 1830s. However, by then, these changes were not implemented because in the aftermath of the collapse of older Caribbean economies after the abolition of slavery, no one would pay for them. Okay, so imperial context suggests that we need not to give too much credit to Francis Forbes, co-drafter of the New South Wales Act, and our first Chief Justice, or James Stephen Jr., of whom I could only find a bust, apparently, from the New South Wales Historical Society. And yes, it's worth reading my caption. We should not, however, write James Stephen off too soon, as he clearly moved in the same anti-slavery circles as Nugent Grenville and may have had something to do with that proposal. However, we can credit James Stephen Jr., particularly after he took on the role of permanent legal counsel to the Colonial Office in 1825, with helping to make the New South Wales Supreme Court an even more important model for empire than our paltry Legislative Council. Stephen rehashed versions of the New South Wales Supreme Court for every Crown-ruled colony in the empire, seeking to establish powerful Supreme Courts with independent, professional and salaried judges, largely independent of powerful colonial governments and local elites, most of whom are slaveholders or mired in the slave interest. Between 1823 and 1833, new charters along these lines were drafted for the Cape, Ceylon, Mauritius, Sierra Leone, St. Lucia, Trinidad, and British Guyana. And the point I want to make about those jurisdictions is none of them was governed by British law. They kept foreign law in all of those places and yet still sought to impose a similar Supreme Court model. Viewed in this light, our first Supreme Court was part of a pan-imperial moment that started in counter-revolution and evolved into a conservative drive to remake empire in the wake of the Napoleonic Wars. So let me conclude by talking a little about the limits and promise of this moment. First and most importantly, it was no vast leap towards liberal self-government in the colony of New South Wales. The effort to establish legislative councils and to create competent courts in New South Wales, the Cape, Ceylon and elsewhere was about shoring up Crown power against growing radical critiques that Crown government, that's ruled by the Crown without a legislature, was tyrannical and unjust. So especially in the context of the West Indies, but also partly in evolving controversies about magistrates' power in New South Wales, we see that centralisation was a core strategy of court reform. It was about giving the centre power to populate and thereby control the courts. Legal Commissioner Fortunatus Dvoris wrote to the colonial, unfortunately named, obviously, wrote to the Colonial Office of the benefits of appointing your judges in self-governing colonies in the Caribbean. Other commissioners urged that judges and other office holders be sent out from England and not joined from local planter elites in the lead up to the abolition of slavery. Importantly, increasing Crown power in empire was not always about despotism. Many, including and especially anti-slavery advocates, thought enhanced Crown power in the colonies could protect vulnerable subjects against the tyranny of local colonial governments, particularly slaves. So judicial reform in the 1820s was part of a concerted effort to govern empire better, responding to the expectations of colonists and making law more predictable and just for creditors, merchants, settlers and slaves. It was inevitably about making law more just, but with the purpose of thinking that the Crown was the best person to do that, central or the best body or office to do that. Now, I intentionally left convicts out of that list. Indeed, the fate of convicts after 1823 in New South Wales stands as a hallmark of the illiberal bent of the 1823 reforms. But of course, councils and courts were never simply vectors of Crown power and counter-revolution. Colonial councils, however tightly controlled, legislated against the will of the Colonial Office with startling alacrity. And as John McLaren pointed out some time ago, and Bruce reinforced today, courts and judges in particular went on to cause a great deal of trouble for autocratic governors across the empire. Whatever Crown plans were, new judges and new courts went on to transform the legal systems over which they presided, acting as a bulwark against some, but not all, of the excesses of counter-revolutionary empire. Thank you.
Thanks. Thanks very much, Lisa. I'm hoping that Emeritus Professor Stefan Petro is on the line, so we'll.
I'm here. I'm here.
Great, Stefan. We hand the floor over to you.
Okay, thank you very much. I'll start today by talking about the major theme of my paper, which is reflected in the title, and then turn to some aspects of the Lieutenant Governor's Court in Van Diemen's Land, where the population in 1816 was just under 2,000 people, and by 1824, just over 10,000, including a sizable percentage of convicts and ex-convicts. So in 1991, legal historian Alex Castles argued that frontier-style conditions for the working of the law predominated in the penal colony of Van Diemen's Land from 1803 to 1824. What he called the frontier paradigm resulted in special adaptations and accommodations in the working of the law, which usually occurred in legal ordering in new societies and in developmental circumstances. So this occurred in Van Diemen's Land due to a range of factors such as geography, convictism, and other local conditions, and possibly mainly because the failure of the British authorities to provide legal machinery to suit the local situation. Related to these factors, Castles asserted, was the development of a Vandemonian spirit, which consisted of a strongly independent frame of mind, a deep suspicion of authority, healthy cynicism about it, refusal to take things at face value, a capacity to battle on in the face of adversity, and an ability to come to terms with difficult conditions. So Castles inclined to see the Vandemonian spirit as embodied in ex-convicts, while I think it was a characteristic of free settlers and pervaded their thought patterns, and I think this is illustrated by the Lieutenant Governor's Court. But both groups had their own reasons to be suspicious of government power and wished to circumvent or evade it. Consequently, Vandemonians did not view the restrictions imposed by English law as especially sacrosanct, manipulated its practical application, and showed that its authority could be far from monolithic, subject almost to whim at times. Hence, magistrates, sometimes with official sanction, mostly ignored the strict letter of the criminal law, while Deputy Judge Advocate Edward Abbott in the Lieutenant Governor's Court, operating from 1816, showed special adaptability to local conditions when deciding civil cases and exemplified Vandemonian traits. And referring to the appointment of legal amateurs, that is, they had no legal training, David Collins and Richard Atkins as judge advocates, Bruce has noted a similar willingness to depart from some of the laws of England in New South Wales before the Second Charter of Justice in 1814, and attributed this to the need to adapt or modify the law to suit local circumstances. Bruce pointed out that in Van Diemen's Land, the Lieutenant Governor's Court also adopted flexible judgment practices similar to those of Atkins in Sydney. So Abbott, as another legal amateur who had resided in Sydney for some years and been appointed a magistrate there, must have been aware of how Atkins approached his cases. So Alex Castles elaborated on the arguments from that 1991 article in his unfootnoted 2006 book, Lawless Harvests, or God Save the Judges. So my paper, in a sense, pays homage to Alex's research and accepts his overall analysis, but I modify and expand on some of his points, give greater voice to participants, both hostile and friendly, in the legal system, and note the role of Lieutenant Governor Sorrell in invariably upholding the independence of the rule of law and the court system. So that's the overview. I now want to turn to what is really section 4 of the paper that you've got, and mention some aspects of the Lieutenant Governor's Court, Van Diemen's Land's first court, and delineate the main ways it departed from English practices and adapted to local conditions. So before 1814, it was too expensive and time-consuming for parties in Van Diemen's Land to bring private disputes before the Court of Civil Jurisdiction in Sydney. So, sanctioned by Governor Macquarie, such cases were dealt with by the local justices of the peace, which made sense as most disputes were over relatively small amounts. But as the economy and population grew, disputes became more complex, and arising from the second Charter of Justice for New South Wales 1814 necessitated major changes in the court system of both New South Wales and Van Diemen's Land, as we've heard. So this is where the Lieutenant Governor's Court was established in Van Diemen's Land, and as preeminent colonial historian John West put it, terminated the absolute dependence on Port Jackson for judicial relief. So the Lieutenant Governor's Court was presided over by Deputy Judge Advocate Edward Abbott. Now, interestingly, in a dispatch to Earl Bathurst, Macquarie regretted that a lawyer had not been entrusted to oversee a court from which there was no appeal. Macquarie pointed out that Abbott's total unacquaintance with law proceedings must render him very unequal to the duties of Judge Advocate. Macquarie predicted that the spirit of litigation, so long hampered and so prevalent in Van Diemen's Land, will meet very inadequate check from the administration of laws by Mr. Abbott. Macquarie was wrong on both cases. After a period of contentious delay, finally, in January 1816, the Lieutenant Governor's Court began work with full power and authority to hear and determine in a summary way all pleas concerning lands, tenements, hereditaments, and all manner of interest therein, and all pleas of debt, account or other contracts, trespasses, and all manner of other personal pleas whatsoever within Van Diemen's Land, where the sum in dispute shall not exceed value of £50 sterling. So Lieutenant Governor's Court basically sat in Hobart only, very rarely went to Launceston in the north of the island, sat for 4 sessions a year, each of 28 days in January, March, July and October. But in vacation, the court was always open to receive plaints and issue process. It was the first local court in Van Diemen's Land in which the active practice of law began on a regular basis. First by persons called agents, nearly all without legal qualifications, only found one with legal qualifications, and from 1820 by a few qualified legal practitioners who came from Britain. As Castle succinctly put it, the Lieutenant Governor's Court reflected a gradual but perceptible movement away from the frontier-style conditions which had previously limited the effective working of the law. And the Lieutenant Governor's Court furnished a special means of community self-help to overcome the deficiencies in the working of the law. It regulated business transactions with minimum fuss and at relatively little cost, operating similarly to a group of English tribunals known as courts of request. But as Castles argues, it was to a large extent Vandemonian in character and reflected its community by setting aside traditional distinctions based on sex, the convict origins or otherwise of members of the community, and formal legal niceties to help ensure the better ordering of its business affairs. Perhaps to preempt criticism of his lack of legal training, Abbott, referring to the nature of his court, declared that some think it is a court of law, but it is not a court of law. Some think it is a court of equity, but it is not a court of equity. It is a court of justice and right, as laid down in the Second Charter of Justice. Bruce Kircher contends that the looseness of that phrase had accounted for the pluralism of early Van Diemen's Land law, and we can say in Van Diemen's Land law too. West called Abbott a lover of fair play. Plaintiffs often confronted Abbott with imperfect proof, but, writes West, the substantial equity of his decisions was rarely questioned except by highly self-interested plaintiffs, as I note in the written paper. Now, Abbott did not sit alone, as we heard earlier. he sat with two fit and proper persons, usually impartially selected by Lieutenant Governor Sorrell from a list supplied by Abbott to act as assessors, which gave Abbott their opinion on the evidence submitted. So this pool to choose from was very small. No assessor had legal training. Mostly they came from the principal merchants and dealers of Hobart Town, many of whom also dominated the court as plaintiffs. To secure equitable proceedings, members were changed every session from 1816 to 1819, except in 1816 when two magistrates served in all four sessions because they couldn't find fit and proper persons. Thereafter, only 2 men served in 2 consecutive sessions, and out of a total of 20 members who served with Abbott, 13 men served only once. Abbott certainly avoided too much legal formality. John West put it best: Abbott held in contempt the network of the law by which equitable rights are sometimes entangled. Abbott allowed convicts and married women to be litigants, although contrary to English practice. Of course, establishing who was married was not easy, so here was an example of adapting the law to suit local conditions. One of the problems we have with studying this court is the fragmentary nature of the official records, which make it hard to assess exactly how many women acted as agents in the court. But I've gone through the records that we do have, and there was certainly a number of women who often acted as agents for their husbands. And perhaps the most prominent was Maria Lord, a former convict transported for stealing, who became a very successful businesswoman and acted as an agent for her husband, Edward Lord, on multiple occasions in 1820. Now, if we have time, and it's doubtful that we will, but I could come back to examples of women. And so can I point to the paper and look up Margaret Whiteman, and you'll be really come across a diamond in the rough that I found, and ex-convicts as agents. How did Abbott and merchants manipulate the £50 limit? How he prevented at times merchant exploitation, and how he acted harshly with convict workers. He rarely found in favour of convict workers who said that their masters hadn't paid them enough. There might also be time to say something about criminal matters, how they were handled in Van Diemen's Land. But now let me go to the conclusion. So on the 25th of February, 1824, less than 3 months before it closed on the 10th of May, Abbott noted that over 9 years, the Lieutenant Governor's Court had tried 5,162 cases, independently of a great many more which were entered and withdrawn, and he trusted gave general satisfaction. If anyone was dissatisfied, he confidently declared that no blame is attached to the members or myself, as we have conscientiously discharged our duty. The fault, if any, must rest with the evidence or the want of it. And Abbott's assessment was supported by the opinion of non-lawyer, agent, journalist and former soldier Robert Lathrop Murray, who had been transported for bigamy and became, and here's a link with Malcolm's paper, or Alan's paper, the so-called leader of the bar at that time, even after legal practitioners were active. So Murray praised the working of the court, where he said substantial justice was, whatever may be said to the contrary, administered therein in most cases. And he thought its great advantage was its cheapness. So the Lieutenant Governor's Court certainly played a significant role in regulating community activities during a difficult period of economic transition in Van Diemen's Land. With all its flexibility, though, the Lieutenant Governor's Court could not regulate the more complex business cases beginning to occur in Van Diemen's Land in the early 1820s. While Abbott had run the court with success and sensitivity, it had started to outlive its usefulness as the demography and the economy of the colony changed, and a court with a wider jurisdiction, the Supreme Court of Van Diemen's Land, was needed and opened on the 10th of May 1824 under Chief Justice Pedder sitting alone. Thank you.
Thanks very much, Stefan. So to our final speaker, Malcolm Shivens, speaking on his own behalf.
Yes, it's me again. Thank you, and thank you for the invitation to present today. If I followed the dates correctly today, I think the Tasmanian Supreme Court beat this court by 7 days. So yeah, there we go. In my paper today, I've attempted to cover the, hopefully there's a PowerPoint. If not, we'll move on. Thank you. In my paper today, I've attempted to cover the historical origins of what is regularly now referred to as the guardianship jurisdictions in both New South Wales and Tasmania, which is primarily my background. Given the limited time I've got, though, I'll only touch on the historical aspects. Many have written, in particular, Justice Lindsay on that extensively. I'm going to take a bit of a liberty and use the conference theme to talk more about the current jurisdiction and proposals for reform. A person's ability to determine their own future and to make choices about their own personal life circumstances strikes at the very heart of what it means to be human. So what happens when a person's capacity to make decisions for themselves about important issues affecting their everyday life and the management of their assets is impaired? With the ageing Australian community and growing rates of dementia, this is an area of interest to nearly all families. These are not new questions, but have their origins in the time of the Chancery, where the law started to try to find ways to answer these questions through formal legal structures. The inherent patria powers of the court in both New South Wales and Tasmania form the basis of the current guardianship jurisdictions. The historical origins of that jurisdiction in the Tasmanian courts were discussed by Chief Justice Blow in the case of the Public Guardian and the Guardianship and Administration Board in 2011. His Honour noted that the emergence of the initial legislative provisions pertaining to the guardianship of adults with disabilities within the Tasmanian jurisdiction only began after the 1920s, despite the Supreme Court having been established in 1824. Notably, the Chief Justice makes reference to the Charter of Justice, a foundational document instrumental in bestowing jurisdiction over individuals deemed to be natural fools or lunatics. Subsequent advancement in this area came following the Tasmanian Parliament's enactment of the Mental Deficient Act. This legislative enactment is notable as Australia's first statute dedicated to individuals with intellectual disabilities, departing from the use of derogatory language such as lunatics or the insane. This legislative progression marked a transformative juncture, signifying a paradigm shift towards the need to employ mindful language when referring to individuals with intellectual disabilities. The Mental Deficient Act was repealed and succeeded by the Mental Health Act 1963. This revised statute established the Guardianship and Administration Board. In 2021, the board was amalgamated with 9 other tribunals in Tasmania to form the Tasmanian Civil and Administrative Tribunal, mostly known as TASCAT. Similar to Tasmania's historical origins, the guardianship jurisdiction observed in New South Wales was transposed from the English law of the mentally unfit. The Lunacy Act 1878 in New South Wales established the position of the Master in Lunacy, which later evolved into the Master in Protective Division in 1972. Always feels like there should be a "the" in there. I gather there's not. The enduring influence of the Lunacy Act persisted until its repeal, being replaced by the Mental Health Act 1958. A legislative manoeuvre driven by the Parliament's objective of aligning New South Wales statutes with contemporary societal attitudes. The language used within the Act replaced antiquated language, such as Tasmania did, as lunatics, idiots and hospital for the insane, with more contemporary language such as the mentally ill and mental hospital, a reflection of evolving societal attitudes again. The Mental Health Act 1958 addressed matters pertaining exclusively to individuals with mental illness and therefore did not address adults or children with cognitive impairments. Subsequent reform was seen in the enactment of the Disability Services and Guardianship Act 1987. A foundational principle of this Act was substitute decision-making, wherein paramount consideration was given to the welfare and interests of persons with disabilities during the decision-making process, and that remains a core principle of the current New South Wales legislation. This protective function of the state has extended to fall within the purview of tribunals. First, the Guardianship Board of New South Wales, then the Guardianship Tribunal, and subsequently the New South Wales Civil and Administrative Tribunal, or NCAT. through the vehicle of the Guardianship Act 1987, which explicitly provides for the tribunal's jurisdiction to adjudicate on guardianship matters together with the Supreme Court. So turning to the here and now, there's no doubt that the vast majority of proceedings dealing with the appointment of substitute decision makers for those with a cognitive disability are dealt with in the respective tribunals as opposed to the courts. The workload of the tribunals has increased significantly over this time. An analysis of the workload growth of the respective tribunals in New South Wales and Tasmania over the last 20 years illustrates a similar pattern. Sorry, slide behind. So in 2002-2003, the former Guardianship Tribunal of New South Wales received 4,200 applications, at which time the population was around 6.5 million. In the same period, the former Guardianship Board of Tasmania received 399 applications when the population was 475,000. We move forward to the last reporting period, 21-22. The Guardianship Division of NCAT received nearly 15,000 applications, and the New South Wales population had grown to 8.2 million. The Guardianship Stream of TasCat received 1,603 applications over the same period, and the population had grown to 570,000. These figures illustrate that whilst application rates had grown over 20 years by 254% in New South Wales and 312% in Tasmania, the population growth rate in each state was only 25% and 20%. In rough terms, the rate of applications to each tribunal grew tenfold compared to the population growth. I can only hypothesise a number of contributing factors to this. One factor is simply a greater community awareness of the need for legal authority to make decisions on behalf of someone else. Another factor is likely the ageing demographic of Australian society and the resulting increase of people with dementia. While such workload growth has presented many challenges to both tribunals in New South Wales and Tasmania, which I've been privileged to be a part of, there are features inherent in both tribunals which equip each to deal with such challenges. For example, both jurisdictions still maintain a long-standing practice of allocating multi-member panels to hear guardianship matters, consisting of relevant experts in addition to legal practitioners such as geriatricians and psychologists. Both tribunals have proactive and appropriately skilled registry staff who prepare matters prior to hearing, such as triaging applications and doing their best to engage with the person at the centre of the application and their families as appropriate. Both tribunals also have the ability to appoint a separate representative to ensure that the person with the alleged disability has their views placed squarely before the tribunal. The jurisdiction exercised today by both NCAT and TasCat is often described as a best interest model of substitute decision making. That is, those appointed to make decisions for others are required to make the decisions which they subjectively believe are in the person's best interests. In Tasmania, the present framework to ascertain the necessity for a guardian is three-pronged. The tribunal must be satisfied, firstly, that the person has a disability. Secondly, that the person lacks decision-making ability due to that disability. Thirdly, that there is an actual need at that time for an appointment. In addition to these three elements, the legislation guides decision makers to ensure that they're satisfied that the decision is in accordance with certain principles. These provisions require the tribunal to adopt means which are least restrictive of the person's freedom of decision in the given circumstances, to promote the best interests of the person, and to carry out their wishes and values. In New South Wales, while some of the terminology used is different, such as the term financial management is used rather than administration, the legal framework is largely the same. The vehicles available in Tasmania, once there is a decision to make an appointment, are a private guardian or the public guardian to make lifestyle decisions, and a private administrator or the public trustee to manage the person's estate. The instruments available in New South Wales are a private guardian and the New South Wales trustee and guardian. So what are the proposals for the future in both states? The prevailing model of decision-making exercised, as I've stated, is a best interest test. This style of substitute decision-making is increasingly criticised for being paternalistic, signifying changing attitudes towards the concept of capacity and guardianship. Contemporary thought follows the rationale articulated in Article 12 of the UN Convention on the Rights of People with Disabilities, which moves away from a best interest model based upon the person's will and preferences. Both the New South Wales Law Reform Commission and the Tasmanian Law Reform Institute have released final reports recommending wholesale changes to the regimes in each state. The New South Wales Commission released their report in May 2018. The Commission recommended that the current legislation, including both the Guardianship Act and the Powers of Attorney Act, be completely replaced by a new Assisted Decision-Making Act. The new Act would introduce formal supported decision-making, whereby a person with ability could enter into a personal support agreement, or alternatively, NCAT could appoint a supporter to facilitate supported decision-making. Whilst NCAT could still appoint a substitute decision-maker, labelled a representative, it could only do so as a last resort if the person lacked decision-making ability. The Act would prescribe that a person has decision-making ability for a particular decision if they can A, understand relevant information, B, understand the nature of the decision and the consequences of making that decision, C, retain information necessary to make the decision, D, use and weigh the information, and C, communicate the decision in some way. A representative appointed by NCAT would be required when making substitute decisions. They'd first have to be guided by the person's expressed will and preference. If that could not be achieved, then they would need to follow out what they likely believed was the person's will and preferences. If those two elements were not satisfied, then they can move to make decisions that were in the person's personal and social well-being. There's still in the proposal, though, what I'd call a safety fuse or valve, and that is that if the person's will and preferences would not, the substitute decision maker would not need to follow the will and preferences if to do so would create an unacceptable risk to the person. At the time of writing, the Commission's recommendations have not been advanced in the New South Wales Parliament. Conversely, recommendations for reform made by the TLRI in December 2018 have been enacted, and further reforms are currently before the Parliament in Tasmania. The recommendations of the TLRI were separated by government into 3 tranches. The first tranche of reforms was enacted in 2022 and introduced a legislative framework for advanced care directives, and TASCAT has the role of maintaining the register and can also make determinations upon application as to the validity and interpretation of those advanced care directives. The second tranche of reforms are actually before the Tasmanian Parliament last week and this coming week. The proposed reforms in the main replicate the proposed reforms in New South Wales in relation to the concept of decision-making ability and the requirement for substitute decision makers to make decisions in accordance with the person's will and preferences, unless to do so would result in harm or the risk of serious harm to the person or another person. The current proposed reforms, however, would not establish a legislative framework for the appointment of formal supporters, unlike the New South Wales proposals. If this were to proceed, the government has indicated that this would be part of a third tranche of reforms to come later. The proposed reforms are not without controversy. Some quarters have been critical of the reforms, labelling them as inadequate, particularly by the failure to include formal supported decision-making. I wish to conclude by touching on the potential challenges of some of the proposed reforms. The manner in which various guardianship frameworks are operating around the country in attending to decision-making for the needs of people with cognitive disability has perhaps been under more scrutiny in the last year or two than any time in the last 200 years. You only need to have watched Four Corners or God forbid, A Current Affair in the last year to know that there's been significant media attention in recent times on what are perceived to be the many failings of the current guardianship systems. There is no doubt that future reforms will focus upon the centrality of a person's will and preferences and optimising support mechanisms to allow the person in question to make their own decision wherever possible. It's hard to categorise this shift as anything but a welcome progression and appropriate. However, like many reforms, the devil will be in the detail, and their successes will be contingent upon adequate resourcing being made available. This paradigm shift, as I've said, is not without risk. The move away from formalised substitute decision-making to supported decision-making requires scrutiny to ensure the framework that is implemented generally enables a person to make their own decisions with support. Put simply, true supported decision-making is key, not just a change in labels. A particular challenge to achieve this, again, is funding. If I could just give a purely personal example of my concerns at its base level as to the label change as opposed to actual change, I am the NDIS nominee for my younger brother who has Down syndrome. We recently attended an NDIS plan review together where the NDIA representative asked about 30 questions. One of them included, do you think you're receiving adequate support to access your community? Darren was challenged by the process and after about question 3 happily went off to finish watching an episode of Doctor Who, whilst I answered the remaining questions to the best of my ability. When the plan was set out to us, it was full of quotations that it is Darren's wish or Darren told me. And when I inquired why the plan had been written in that manner, when clearly I'd given the responses, I was told that the NDIA required this as it promotes supported decision-making. I hope I'm not sounding too cynical. Another possible outcome associated with the formalisation of supported decision-making may be the perverse outcome whereby many people with cognitive disability are drawn into the tribunal's vortex for orders, having hearings year after year or twice in a 3-year cycle. The vast majority of Australians living with a cognitive disability have never had to enter the guardianship system. Most are supported by family and alike informally to attend to the necessities of life, whether that be to lodge a claim at Medicare, to make a payment for utilities or to open a bank account. Prudent organisations will understandably wish to be satisfied that such supporters are formal supporters once there is such a concept in place. This in turn will shine a spotlight as to whether the person can indeed be supported to make their own decisions. There is the potential that this spotlight, rightly or wrongly, may force many families, probably including my own, to seek formal orders to attend to the usual support activities that they've attended to for 40, 50 years without any question. Finally, there are some areas of proposed reform where the focus on supported decision-making can seem incongruous with fundamental legal principles. A prime example of such is the use of restrictive practices. A restrictive practice, at least as defined for Commonwealth NDIS purposes, is any practice or intervention that has the effect of restricting the rights of freedom of movement of a person with disability. Practices may include the use of medication to control behaviour, or physical restraint or seclusion. These practices need to be used when a person is engaging what are currently contemporaneously labelled behaviours of concern, which may harm themselves or others. An example is perhaps the need to lock the door in a group home to prevent a person with disability who may be harmed by passing vehicles if they are able to move into the road. At the core of these practices, without appropriate authorisation, they would otherwise likely amount to assault or false imprisonment. The tribunals in both New South Wales and Tasmania are regularly called upon to adjudicate as to whether substitute consent should be provided for these practices to occur. There are now proposed reforms in Tasmania which call for people with disability to be supported to provide their own consent for the use of restrictive practices. In a summary report issued by the Department of Communities Tasmania in 2022, the recommendation was made that the Tasmanian Government implements supported decision-making frameworks within its restrictive practices authorisation processes. Whilst the obvious starting point is, of course, that a person with disability is presumed to have capacity to consent to such practices until the presumption is rebutted, the practical reality is the majority of people who exhibit behaviours of concern to this degree often have the most profound intellectual disability. Many are unable to communicate their most basic wishes. It is questionable as to the proportion of people who require the use of restrictive practices who could ever generally be supported to provide their own consent. There's also the legal quandary as to whether any such consent provided is in fact withdrawn by the person's actions at the time they are exhibiting the behaviours of concern. No matter what reforms are ultimately enacted in both New South Wales and Tasmania in the years ahead, there is no doubt that the adjudication task of the respective tribunals will remain as it is now, a complex balancing act and is characterised by Justice Lindsay as the struggle for perfection in an imperfect world. Thank you.
Thanks very much, Malcolm. I haven't quite had to herd cats, so we have a few minutes left. If anyone would like to ask any questions of our panellists. I know afternoon tea is beckoning, but...
I have a general question for the history panel. I think we've had a really interesting narration of the various influences on the development of the court systems here, both in Tasmania and New South Wales. I don't know if this is too broad a question, but I'd be very interested to hear the historians talk a little bit more about the dissonances in the way that the law was developed in Australia compared to the British law. For me, one of the most impactful findings of Bruce Kirch's work was just the extent to which we had to modify the law, the British common law in Australia, because you couldn't have a system of law with most of the local population being dead to the law, as they would have been in Britain. But I'm also interested to which, in the extent to which the race element in Australia led our first jurists to really make the law up as they were going along. Thanks.
Is Bruce still with us?
If Bruce is here, Bruce, would you like to comment?
Yeah, glad to. The point about convicts, and I think you're talking about Cable and Sinclair, the very first case in July 1788, where a decision was clearly made without being articulated that the laws of attaint would not apply in New South Wales, when by 1824, with proper advocates and properly qualified judges, it was no longer possible to ignore that, nor to do what they had done earlier under Baron Field, just find a way to avoid it. They had to meet it head on. And in doing so, there was some subtlety there. As far as Aboriginal persons go, there was, I guess the opportunity to do something fresh with the Indigenous people of Australia was missed with the Ballard case. That was where I didn't say much about it. That was where both Forbes and Dowling were saying there's no reason for these people to follow our law in a clash among themselves. They have their own ways of dealing with it, and we ought to recognise those ways of dealing with it. Then came the Murrell decision, and then later we got the Bonjon decision, where I can't remember the name of the judge, the New South Wales judge in Melbourne, Willis. That's right. Thank you. Where Willis, in effect, reverted to Ballard. There was a struggle going on. I just didn't get the impression that the judges were as concerned about. It's important not to make these judges into something they weren't. They were not liberal Democrats of the 21st century kind by any means. But I just didn't get the impression that the struggle that went on in dealing with the injustices to Aboriginal people were dealt with as seriously and extensively as the struggles that went on over the rights of convicts. I don't know whether Lisa, Lisa, you've been working in similar areas. In fact, holy cow, you certainly did. I don't know what your view is.
I think. Are we good? Okay. I'm still echoing. Okay, good. I think that there was a real wait and see attitude towards the relationship between the British Crown and First Nations people. And I think Bruce is right. You know, the first person, First Nations person to be tried for harming a settler was not tried until, was it 17 or 18, like 20 years after settlement. So when we say British law applied, well, in fact, mostly it was just violence. And so it was state-sponsored violence in relation to interracial conflict. And that person was an adoptee. So, you know, the first case that said unproblematically, the lex loci as British law was later. And that was simply because it was the most convenient and, you know, it was the most legible framework, right? Arguably, you would always do that if you're the prevailing court and you'd arrested somebody. Those sorts of questions were answered really slowly in Australia. So I've forgotten the date, but there's a date about who owned the cows. We were talking last night about, these cases that weren't about, or this morning about cases that weren't about First Nations people at all. But did the king own the wild cows? Well, there was a case that said that he did. So these sorts of things came up, but it wasn't central, Mary. It was peripheral. And at one point, Burton was the first person to say, actually, this is central to the British claim, or the Crown's claim to be able to keep the peace in this continent. And that was a really weird thing to do, right? Because I was just talking to the people earlier about this wonderful new book about state making, or defining the state in the Austro-Hungarian Empire in 1850. Natasha Wheatley, you should all read this, it's beautiful, if nothing else. But what these people did is they kind of broke the empire by trying to write the state. So writing the state as this perfect sovereign entity is something that happens very late. In some ways, we do it quite early, which, again, probably reinforces the importance of your question. I've just given a really rambling answer, but these things are not clear. They happen slowly and they happen imperfectly. And just remembering the Tom's case we were talking about this morning, Burton, in those extensive notes, refers to First Nations people as permanent aliens, which is so rich and interesting given the way that jurisprudence is developing in Australia right now. So, it's messy and it's evolving.
I'll just give Stefan the opportunity. Stefan, do you want to add anything?
It's all been summed up, thanks.
Okay.
I suppose what moves me is that the discourse on terra nullius was accompanied by a discourse that, and I guess my question sort of leads into this, the extent to which there were some settlers who were arguing that the Indigenous people were not even human. Look, Henry Reynolds has written extensively about the extent to which we knew what we were doing. So I guess that's what was behind my question.
You want to respond to that? Yeah, Prue. Sorry about that.
I just wondered if anybody would like to comment on the fact that the third charter or the legislation that went through was supposed to legitimate the whole colony in a way that hadn't happened before because it was only royal prerogative that was being used earlier. Has anybody got views about that and whether it really mattered or not?
It did. I probably should. It really did, right? Because it wasn't conquered. Those conquered colonies, they hadn't again, and I know I like messiness, probably too much, Mary, but whatever. So if you look at what happened in Quebec, because it was conquered, it wasn't a problem. Like the Crown got to decide, like Campbell and Hall, the Crown got to decide, and after it had settled a constitution, which was totally at its whim, subject to some underlying principles, Parliament had to help. But that didn't apply in New South Wales. So the problem with the competency of the governor to legislate was really very important. So they did need to legislate for New South Wales. They needed to legislate because there were increasing and really more and more consequential issues arising about the problem of the status of local legislation, taxation, all of those things.
Yeah, and in fact, my paper supports what you said about James Stevens' opinion. He gave an opinion in 1823 on this and how important it was and how they relied upon it. Yeah.
Bruce or Stefan, would you like to add anything?
No, I don't.
Nor me. That's a question for Lisa, definitely.
Wasn't part of the significance of the 1823 Charter after Biggs' recommendations that the colony, with some emancipations, etc., had become something very different from what was originally intended. And so there was an incipient economy. There were different types of disputes arising than those which were originally anticipated given the original purpose. And so the first two models weren't really adapted to what had developed, contrary to the original plan, and so that's part of it. I think.
And the, everyone quotes Bathurst saying it needs to be an object of real terror, but he actually wrote 3 or 4 letters to Big on the same day, many of which said, we kind of know that ship's already sailed and that this now has an incipient economy that's growing and that needs more adequate institutions. And he was actually directed to look in, particularly in the context of the judiciary, to how to manage these more complicated disputes, given that it already was more than a convict colony. So part of those letters was also, well, maybe we should just put the convicts elsewhere.
But you see that the commercial side of it in the different levels of jurisdiction, monetary levels of jurisdiction, which sort of emerged, different layers of courts.
And what's really interesting too is that moment of what they call gentlemanly capitalism, right? Kane and Hopkins talk about this. There are no gentlemen really in New South Wales, but Big proposes the local equivalent of that, which is to use the state's resources, including convict labour, to sponsor elites. And that's a very, very Liverpool conservative moment response to how to fix pretty much everything.
I'm afraid time has beaten us. We've had 6 wonderfully rich and varied papers. Can I ask you to put your hands together for our speakers? And we reconvene at 4 o'clock. Thank you.
If I can have your attention, please. I'll have to deal later with Justice Lindsay and Professor Lunny, who ran a very lax session that ran over time and have consequently slightly cut down the time for this more important session. Welcome to the afternoon session. My name's Virginia Bell, and I've got the very demanding job of chairing this session, which I can assure you will from now on proceed with something close to military efficiency. The focus, in line with the last session, is on history, but now with an emphasis on the administration of criminal justice in the Supreme Courts of New South Wales and Van Diemen's Land at the time of their establishment, and rather less emphasis, but a little bit, by way of contrast with that administration today. We have three speakers, Professors Kate Warner and Hamish Maxwell-Stewart are presenting from what I'm calling the Red Room in the Supreme Court of Tasmania. And Dr. Greg Woods, KC, is here with me in the Banco Court in Sydney. Each of our speakers has now been cut down to something around 20 minutes, which should leave us with a little bit of time for questions at the end. I'm proposing to introduce each of the speakers now so that we can just flow seamlessly one to the other thereafter. Our first speaker is Greg Woods, whose credentials in terms of the history of the criminal law in New South Wales are truly unrivalled. Greg taught criminal law at Sydney University. He was a leading counsel in criminal cases, taking silk in 1981. In 1997, he was appointed to the District Court, and he sat in that court for the next 20 years or more, presiding over numerous criminal trials. Among true nerdy devotees of the criminal law, he's best known as the author of the 2-volume history of the criminal law of New South Wales, which runs to about 1,700 pages, and we're still only up to 1955. He is working on volume 3 as we speak. Greg's paper is going to take up where Chief Justice Kiefel left off in her paper last night, looking at events after the Third Charter of Justice in terms of the work of the court in the courts in the early days. Next, as Geraldine Doog might say, we're going to drill down into some of the details of particular cases, mainly looking at early cases in the Supreme Court of Van Diemen's Land, and again contrasting the approach to the conduct of trials and sentencing with the work of the court today. That segment's going to be presented by Professor Kate Warner. Now, I'm conscious that Kate was introduced earlier today because she was commenting on this morning's session, but just to recap, she started her professional life as an associate to the then Chief Justice of Tasmania. She's had a very distinguished academic career, including as head of the School of Law at the University of Tasmania and as director of the Tasmanian Law Reform Institute. In 2014, she was appointed as Governor of Tasmania and remained in that position until 2021. Of particular relevance to this conference, Professor Warner is an internationally recognised authority on the law of sentencing. And in our final segment, we're blending history with cyberspace. Hamish Maxwell-Stewart is the Professor of Heritage and Digital Humanities at the University of New England. Of relevance for this session, Hamish is also the CEO of Digital History Tasmania. That's a project that has seen the digitisation of all the 19th century Tasmanian convict records and the hyperlinking of those records to court records and police records and the records of other agencies. that enables Hamish to pursue his research interest, which will be the subject of the final segment, and that is the intergenerational impacts of convict transportation. Without more, I'm going to call on Greg Woods to speak.
Thank you. It's fairly alarming addressing the court in this direction, but at least I have the relief of knowing that I won't be asked any questions from the bench, from judges possibly, but not from the bench. The previous speakers have already reviewed the first, second and the lead up to the third charters of justice, so I'm not going to go through a great deal of that material. I was embarrassed to see, looking back over it this morning, that the paper I've written is 21 pages long, so I won't be dealing with all of it. You'll be gratified to know. If there are any high points, those are the matters I'll be dealing with. The first period of the administration of New South Wales has been referred to by the New South Wales Law Reform Commission in the report which led to the enactment of the Imperial Acts Application Act 1969 as a period of military and despotic government. Well, that's probably about right. You heard about the big reports, and there are two former Chief Justices who've been here today who've written about that, and I won't go into that any further. Apart from being a terrible snob, as somebody remarked earlier this morning, Mr. Big was concerned to cut down costs. So there was a major issue of costs about the administration of the colonies in the south. Between the scholars, there is a slight frisson about which of the two Supreme Courts of Tasmania or New South Wales was the first prioris tempore, etc. In his 2003 study of John Pedder, Dr. Bennett wrote about which Chief Justice arrived first, which Vice-Regal representative was first to promulgate the new charter, and which Supreme Court first began substantive sittings. In 2021, Professor Michael Stuckey entertainingly recounted the two voyages of the two Chief Justices-elect and the travails of Forbes's ship, the Guildford, which caused it to be delayed. Now, many debating points are raised about whether the Tasmanian court can boast priority, but in my view, a reasonable conclusion is that Tasmania and New South Wales share the distinction of being Australia's founding Supreme Court. Now, there may be dissent on that point, but it would be dissent only, as in academic circumstances, about the trivial. Those, from my experience of academia, are the matters which generate the most heat. But broadly, there is substantial equivalence in time. The third charter did, in fact, bring about and was intended to bring about the establishment of a new regime for government and the court system in the two colonies, representing a beginning for the modern separation or approach to the separation of constitutional functions under the rule of law. And there was in each case a Supreme Court which obtained approximately the authority of the courts at Westminster. Now, I'm going to turn to some of the context which I regard as important for the two courts, but bearing in mind what Professor Lisa Ford spoke about, it's important not to forget the situation in which Britain was placed in 1824, the time of the beginning of the two Supreme Courts. It was not a condition of peacefulness and tranquility of mind. The French Revolution had unnerved the British. Lord Liverpool, the relevant administrator of the kingdom, was a fierce Tory, a man of considerable vehemence in his political positions. In 1819, the famous event at Manchester called Peterloo took place, when a large number of protesting workers were chopped down with bayonets, or the curved bayonets they used at that time. The government of Britain was embarked extensively throughout the world in various enterprises of grabbing countryside wherever it could be found, wherever their ships could approach, and dealing with the citizenry if they didn't comply. At roughly the same time as the two Supreme Courts were founded, and this goes to show that New South Wales and Tasmania were not on the absolute top of the list of matters that the government of Britain had to deal with. At that time, there was a major disturbance on the eastern side of India, still under the control of the East India Company, but gradually relinquishing control to the British government. The British government had to send in troops into Burma, and there began the first of a series of wars which occupied Burma and made its resources available to the British Empire and its trading purposes. At the same time, the resilience of the British arms was demonstrated in what was known as the Gold Coast, but is now Ghana substantially, where the Ashanti tribesmen rebelled against British intrusions into their country for trading purposes and control. And indeed, in 1825, the British were defeated, but there were a series of Ashanti wars, and eventually Ghana and the surrounding areas came under British control. So that to the extent that there was in the early period of Australian history, white Australian history, violence on the part of the soldiery and those who had been soldiers, those who were convicts, it wasn't something that was totally foreign to the British character or the British government's policies. And there was there's been reference to James Stephen, there was an evangelical disposition to spread the Christian doctrines of forgiveness, of the truth of the Jesus Christ story, and the validity of exporting Christianity throughout the world. The people who were controlling Britain and who negotiated about the big report, the complaints by settlers from New South Wales about the need for trial by jury and an assembly, those people in London were motivated by the highest ideals of benevolence. And it's one of the great tragedies and enduring, if I may adopt the word from the title of our conference, enduring issues, that there was a conflict between the militarism and expansionism of Britain at that time and the genuine benevolence of many of the administrators of the empire. And that conflict persists today in attitudes about the current argument du jour, the voice election or referendum in a few weeks' time. It is certainly true that Britain was an imperialist nation at that time, making a drive to become one of the great empires of the world, and it achieved that probably at some point in time before the First World War. But the significance of this for the Supreme Court of New South Wales and the Supreme Court of Van Diemen's Land is that we weren't at the top of the list when decisions were being taken. But the decisions that were taken about the structure of the courts and the structure of the law were necessarily affected by the tension between a genuinely benevolent intention to remove the slave trade. One of the early slave trade relief acts was passed in 1824, and the desire to expand and to occupy territory throughout the world. When I was at primary school in the 1950s, every primary school classroom had a map of the world with the pink bits on it, which were the bits that weren't necessarily at that stage entirely part of the British Empire, but they represented what had been the British Empire, and they were very extensive. So that here we were, and as it turns out, the enduring part of the title of this conference is borne out by the fact that these two Supreme Courts, with their birth in complicated political contradictions, have endured, and the virtues that the rule of law brings with it in maintaining stability of government, a fair crack of the whip most of the time for people who come before the courts in one way or another. Those things are very important, and they remain important today. I'd rather be dealt with in the Supreme Court of New South Wales or Tasmania than in Burma, Myanmar. The British may have been nasty in many ways in Burma, as George Orwell's written about in his memoirs. They've been unsatisfactory on the west coast of Africa. They both participated in and attempted to abolish the slave trade that was a marked feature of West Africa during the 19th century. Nonetheless, I think that the importance of the Supreme Court being here 200 years after having been commenced, perhaps 7 days earlier in Tasmania, is something that we can all applaud and be thankful for. Okay. Now, there's been a lot said about the context of the early court with respect to dealing with Aboriginal citizens or people, subjects. Were they subjects at all? Were they sovereign? In the written paper, I've written about that extensively, and I won't repeat myself there, but I will say this. As I've said on the last page of the written paper, that it's a reasonable interpretation of history, both in Tasmania and New South Wales, that the shock of brutal dispossession during the century after 1788 produced such profound damage to Aboriginal communities that the trauma has reverberated down the generations and still affects many individuals adversely. Of course, courts usually deal with individuals rather than with groups, and the contemporary twin Supreme Courts, if I can call them that, when dealing with criminal cases involving Aborigines, apply High Court decisions such as Bugmy and the Queen, with which you're all no doubt familiar, which acknowledge and make allowance for the impact of a grim history on the culpability of particular offenders. And in this respect, the two courts, the Tasmanian and the New South Wales courts, share the beneficial effects of the overarching High Court, which draws upon the jurisprudence of the courts in the states and territories, but lays down important overriding principles. Now, in the course of my experience as a district court judge, I spent decades conducting criminal trials and sentencing people. And I've got a lot of experience in sentencing people of Aboriginal background. And the most difficult part of it is when the damage done by the accused, if it has been done by the accused, was damage to another Aboriginal person, which is not infrequently the case. So that it's a shocking dilemma. The courts in Bugmy, and basing that on Fernando and a few other decisions, Chief Judge of Common Law Wood laid down an important principle in Fernando's case that the history of dispossession and its impact on Aboriginal offenders is of particular significance. I think that's why, in my awareness of the debate over the last 6 months or so, 12 months, most of the legal profession who are familiar with these concepts don't have any problem with the referendum and the vote yes. And I think most judges and magistrates are aware of the dilemmas to which I've been referring. Look, I could go on at length, but I won't. Suffice it to say that I'm very grateful for the kind words of my learned leader today. And I'm very grateful to have heard the speech on Friday night by the Chief Justice. And I wish well to everybody involved in this. I noticed there are a number of students here, and I'm grateful to see them. I used to teach legal history before it was abolished in the law courts, the law courses of the universities, and I hope it's reinstated. Thank you.
On that clarion call, we'll now move to Tasmania and to Professor Warner. Thank you.
Thanks so much. And thank you very much for the opportunity to speak this afternoon and to really the opportunity to delve into the then of criminal justice. I've really enjoyed the process. And I have to say that I'm not a legal historian, so I thought it would be quite sensible to focus on the micro view of things and to delve into some of the early cases that were heard by the Supreme Court of Tasmania when it first started sitting. So from these cases over the first 3 years, I drew out two themes. The first one is the trial of Aboriginal defendants for resisting white settlement. And the second theme is the prosecution and trial of sex offences. But you'll see in my written paper that I did set the scene, but obviously we've had a lot of talk about that already, so it's really no longer necessary for me to talk about that. Now, just looking at the first 3 years, I had a look at the law reports. The law reports, there were no official law reports, not until much later. But Bruce Kircher and Stephen Petro have comprised a database of Supreme Court cases derived from newspaper reports from 1824 and onwards, and they're available on AustLII. So I used those. I also went to the archives and looked at the minute books too, and used Trove to supplement the information. So just looking at the minute books and to those early law reports, you can see the kinds of cases that were heard in the court. Murder, burglary, sheep stealing, highway robbery, larceny, forgery, and some sexual offences. But looking at the minute books, it was definitely the property offences which were most dominant. And the sentences were death penalty for murder, sheep stealing, burglary, forgery, and for rape. So another couple of interesting things from the minute books which surprised me, and that was the huge volume of work. So the Chief Justice presided over 62 trials in the first 2 months of the sitting of the court. And the days were long, often until 7 p.m. And even one case I noticed from the minute book went till midnight, and there were Saturday sittings as well. But I'm going to start with the first trial, and this is the trial of the King against Tibbs. And Tibbs was indicted for the manslaughter of John Jackson, described as a black man. Another question arises, I won't go into the facts of the case, but an interesting sideline to this was he really an Aboriginal man? Was he Palawa, as J.M. Bennett, Plomley, Cox, Windshuttle and Sir Guy Green have claimed? And it was said that the fact that he was an Aboriginal man demonstrated the impartial administration of justice in cases involving Indigenous victims. And that, in fact, some effort was made to prosecute those who killed Aborigines. And it was also claimed too that this showed the benevolent attitude of our first Chief Justice towards Aborigines. However, Jacqueline Fox, a historian, has revealed that in fact John Jackson was not an Aboriginal man, but he was a retired British soldier, a bandsman from North Carolina who'd been transported from Britain for rape. So it seems then that no colonists or convicts faced trial for killing Aboriginal people. However, the criminal prosecution of First Nations people for killing colonists is really quite another story. And so I'm looking at those trials, and there are a couple of them. The first one was the King against Mosquito and Black Jack, and this is reported in 1824. So at the first trial, they were charged with aiding and abetting the murder of William Holyoake. And I have to say there are two conflicting versions to this story. And the first one is the story that was told in court by the principal witness, one John Radford. He was a ticket of leave stockman who was employed by Silas Gatehouse, and he, with a fellow employer, Momoa, and another man, were at Gatehouse's hut in the country on the east coast at Grindstone Bay. And apparently what happened, well, according to his story, a group, and this wasn't contested, it hasn't been contested, a group of some 60 or so Aboriginal people came to camp near the hut on beside a creek. And they were there for some days, and then, according to Radford, one morning there was a lot of activity going on in the camp. So they went outside. He went outside with Momoa and instructed the other man, Holyoake, to stay behind in the hut with the firearms. But Holyoake didn't do this. He left the hut without the firearms, and then when Radford ran back to the hut, the firearms had disappeared. He then says he was confronted. He and Holyoake were confronted by some of the Aboriginal men with spears. They were chased. They were speared. Radford was speared but managed to escape. But the other man, Holyoake, fell to the ground. When he returned a couple of days later, he found Holyoake lying covered with some sticks and with broken spears protruding from his body. So he gave evidence at the trial. He said in his testimony that they had not provoked the attack in any way, nor had they taken any liberties. So the verdict of the jury was that Mosquito was guilty, Black Jack was found not guilty. And then immediately after, there was a second trial and they were charged with aiding and abetting the murder of Momoa, whose body had been found by somebody else some days later. However, there is a counter-narrative told by modern historians, and they state that, and they're relying here on multiple sources, including George Augustus Robinson's diary, and also, I think, Melville as well. And the counter story is that apparently what they think happened was that Mosquito had taken some of the Aboriginal women to the hut the night before, and that this was done to take them there for sex with the white men in exchange for food. But for some reason, one of the women left the hut, and it seems, or it's surmised, that Hollyoake lost his temper and shot her in the back. So there is evidence that this is what happened. However, of course, that official story, that historical story didn't emerge. So while Black Jack was found not guilty, a couple of months later, or a month later, he was convicted of the murder of a hut keeper at Sorrel Plains. And so both men were executed. Both Mosquito and Black Jack were executed. I couldn't find any reports of the second trial or the third trial involving the hut keeper at Sorrel Plains. So it seems that from this time on in the colony, conflict between the Aboriginal people and the colonists really escalated. So in 1826, at least 23 colonists were slain and an unknown number of Aborigines. So the next trial is the trial of Jack and Dick, and they were charged with the murder of Collie, a convict bullock driver. And it seems that in this case, what had happened was that Collie had whipped a young Aboriginal man called Jack, and that Black Dick, an older Oyster Bay man, had speared Collie to death in revenge. So both were tried for his murder, they were convicted and executed. And it's said that Lieutenant Governor Arthur believed that individual members of the Tame mob were responsible for all of the attacks on settlers, and that if they were tried and executed, or some of them were tried and executed, this would be the end of Aboriginal resistance. So on the day of their execution, Arthur issued a notice setting out the legal conditions under which colonists could kill Aborigines when they attacked settlers in their property. Of course, that was not the end of the conflict by any means. So just moving on to the second set of trials that I'm looking at, and these were in relation to sexual offences between 1824 and 1827. And I wondered how often were there prosecutions for sex offences in those years. And I found 6 trials, 5 of which had child victims under the age of 12. Just quickly, I should mention there a little bit about the law in the books. So rape and carnal knowledge of a female under the age of 12, and for that crime, carnal knowledge of a female under the age of 12, there was no need to prove absence of consent. Both of those crimes were capital. And men were executed for rape for long after these offences ceased to be capital in England. And this was justified on the basis of the serious imbalance between males and females on the island. So I think in 1824, male convicts and settlers outnumbered females by 3 to 1. So at that stage too, children could give sworn evidence, but they had to believe in God and have a general knowledge of truth and lies. Otherwise, they couldn't give evidence, and corroboration warnings were required. So the first trial that I found was the King against Farrell, and he was charged with the rape of Margaret Thomas, a child of 9, and also on a second count of assault of her with intent to carnally know her. He was acquitted on the first count, but convicted on the second. And for the assault with intent, he was sentenced to imprisonment for 12 months and fined £10, quite a different penalty than the punishment if he'd been convicted of rape. The second trial is that of the King against Tufnell, and I found this in the Minute Book and then followed it up through Trove in the Hobart Town Gazette. He was tried for the rape of Ellen Briggs, a child of 9, and convicted without the jury even retiring and sentenced to death and executed. And it also appeared from the minute book that the trial had been adjourned from the previous session so that the child could be instructed in the nature of the oath so that she could then give sworn evidence. So she gave sworn evidence, and this was corroborated in many respects, according to the newspaper, by Dr. McNabb. It was also said in the note to the previous case that she was another half-caste girl, but I think it's probably unlikely that she was Aboriginal, because following on from Jacqueline Fox, I think when they talk about a person being a child of a person of colour, it does not mean that they're Aboriginal. They use different terminology. You would have been called a native if you were Aboriginal. So the third trial that resulted in acquittal, and I'll just move on to the fourth trial, which was the King against O'Brien. And this was a case where there were two trials again with respect to the same victim. At the first trial, there was a charge of assault with intent to have carnal knowledge of Anne Carlin, a girl aged just 4 years, and O'Brien was found guilty. He was a private in the 40th Regiment, and there were 4 witnesses in this case: the child, her parents, and Dr. Thomas Landau. The child, it said, gave her evidence very distinctly, and this was corroborated by her mother and father. And also Dr. Landau's evidence proved that the child had been infected with a disease, presumably a venereal disease, by the accused. So I wondered, of course, why was he not charged with rape? Why was he just charged with assault with intent to have carnal knowledge of a child? I mean, I know that you can transmit a venereal disease without having sexual intercourse, but on this occasion I wondered whether in fact he had had sexual intercourse with her and instead was charged with assault with intent to have carnal knowledge. Probably Stefan and others, Greg and Hamish, would better understand why this is the case, but probably, I guess, to try and avoid charging him with something which was a capital offence. William Fowler was another case that I found in the minute book and also in the newspapers. And this was a case which resulted in an acquittal. A directed acquittal for the first trial, and this was because he was then charged with murder. So the poor child had been killed in the course of this. This was a case where there was a lot of information given about the case in the newspapers, which was interesting, much more detail than I found in the other cases. And then the final case I want to mention is the case of Antonio Fonzic. This was the only case I found over 3 years where anybody was charged with a sexual assault involving an adult victim. So it was the rape of Charlotte Cornwall, and the verdict was guilty and he was sentenced to death. But intriguingly, he was pardoned a month later. Now, I'm not sure why he was pardoned a month later. I now understand from Hamish, he's explained to me that there are extensive records of the Executive Council. So they probably would have debated this, the reason why he was pardoned. But I know at that time there were pardons in cases of rape, and this sometimes happened because there'd be a petition in favour of the accused person, stating that they were a good character, and on the contrary, that the complainant or prosecutrix was not a good character, and that perhaps she had engaged in some kind of behaviour which led to the rape. So whether this was the case here, I don't know, but I'd be interested now. I will follow up in the Executive Council minutes and see if that was the case here. But I was intrigued to see why he was pardoned. And I did a little bit more research on Trove into this Antonio Fonsic, as it's such an unusual name. And I discovered, this trial was in Launceston, that Antonio Fonsic was a chef, and he was a chef for the superintendent of police. So I'm assuming this was the same man. It would seem a bit unlikely that there were two Antonio Fonsics in Launceston at the time. And so that may be the fact that he was an extremely good cook, and this fact worked in his favour and led to him being pardoned. I know that these cases didn't always result in a pardon. Sometimes there was a commutation, or the death sentence was commuted to something less, or it was respite in some way. But I don't think the records are quite clear in this case. But it seems that Antonio Fonsic was indeed pardoned. So just the overview of the sex offence trials, it seems it's unusual that most of the cases involve very young children, apart from this one case with the adult. And I think, what about all of the other cases? Why weren't they prosecuted? So questions arising there. It seems that just as today, there's a huge proportion of cases of sexual assault that don't get to court. The same was true in those early years. So I think that I'm running out of time. Clearly, attitudes to sexual assault have changed to some extent, although we haven't progressed enormously. I was just thinking to the definition of rape. When I first started teaching criminal law, rape is carnal knowledge of a woman, not his wife, without her consent. And carnal knowledge was defined as penetration to any the least degree of the organ alleged to have been known by the male organ of generation. And that was our law until 1987. Now it has changed. However, as I say here in this PowerPoint, rape myths and the notion of what is real rape does persist. And there's really no evidence that the rates of victimisation of children or adults is diminishing. And in relation to the treatment of Aboriginal people in the criminal justice system today, I know Greg in his paper, and he had today talked about the overrepresentation of Aboriginal people in the criminal justice system. And this seems to be the case, as we've learnt in New Zealand and Canada. And it seems that this overrepresentation is a consequence of colonisation, and that the effects of this are far-reaching and intergenerational. And I would say that we need a much more appropriate response to avoid the compounding losses of culture, language, family and kinship. And with respect to Greg, I don't think that things like BUGME go far enough. I think we need a different approach to Aboriginal people within the criminal justice system. And I guess the answer doesn't lie within the criminal justice system itself. So thank you.
Thanks very much, Kate, both for your paper and for what I would describe as impeccable timing in presenting it. And now if we can just move to Professor Hamish Maxwell-Stewart.
Thank you very much, Virginia. So we're just setting up the presentation. So it'll be with us in a second. Here we go. There we go. Slideshow. Thank you very much. So I'm going to talk briefly about four things. I'm going to talk to you very quickly about a project that's been going for about 14 years now to transcribe the records of Tasmania held in the Archives Office up until about 1920. And the core part of those records are records that are generated by criminal justice systems, whether those are in England and Wales and elsewhere in the British Empire or in the colony, later state of Tasmania. I then want to just quickly touch on the really important and I think often overlooked role that the courts play and sentencing practices in that colonisation process. And then very quickly, the impact of convict transportation on life course outcomes. And I'm going to do this in two ways. So look at the impact of punishments on life expectancy, and then very quickly tackle the issue of whether transportation was effective in persuading people to desist from offending. So how does it contrast with the prison? And then touch on an issue that both Kate and Greg have picked up on, and the main reason for putting together a data set like this, which is to look at the impact of intergenerational transmission. Now, I'm an economic and social historian, and I'm primarily interested in the intergenerational transmission of social inequality. But prosecution risk is also, I think, a very, very important issue. So this is the data set that we put together. At the moment, it stands at about 2.5 million digitized records. It's by far and away the biggest historical database in Australia. It's the product of a collaboration between the State Archives, academic historians like myself, and family historians. And there are about 100 people that have been involved in pulling these records together. The aim was to start with the convict records. 75,000 convicts landed in Van Diemen's Land, to go backwards into criminal justice records elsewhere, particularly England, Wales, Ireland, and Scotland, to provide some context, and then forwards through the generations in order to look at the impact of convict transportation on subsequent outcomes. So I think a really important part of this is to understand how sentencing changes when a person facing a court in England and Wales or Scotland and Ireland is sentenced to transportation and not to imprisonment. So one of the remarkable things about the Tasmanian data set is that we have records of, we have their prior offending history. It was all transmitted on the convict vessel to Australia. So this is the amount of time in years that convicts spent in prison in Britain and Ireland for all of these offences prior to getting a sentence that would send them to the other side of the world. And this is the mean length of the sentence that sent them to Australia. So why the difference between those? Well, convict labour was loaned out to private settlers. If you take into account the costs of rationing, clothing and accommodation...
Hamish, I'm
Yes?
sorry to interrupt, but we are not seeing the slides that I think are accompanying this part of your discussion.
Aha! Let me hand over to my technical assistant.
Excellent. I hope that technical assistant is doing better than we did with Bruce Kershaw earlier today, just in terms of quality of visual
What can
and
you see
audio.
now? Does that look better, Virginia?
No,
We'll just have to summarise what's...
no, we haven't. I think we're just going to have to continue without the slides, perhaps. Okay.
All right,
Is that-
so I'll just describe what's on the screen. We'll be fine.
Yes, sorry, Hamish.
So there's about 1,000% increase in a sentence to transportation compared to a sentence in imprisonment. The reason for this is sentencing somebody to prison in Britain is very costly. I mean, I emphasize this all the time. You can send a child to Eton for the same cost of putting somebody in prison. And yet, with transportation, the length of sentence has an economic worth attached to it, because the prisoner is lent out to the private sector. And the costs of maintaining them as a prisoner are only 59% of hiring a free worker. So the saving to colonial private settlers is around about £14 million in 19th century money. And indeed, I've tried to be provocative here, but I'm arguing now that the British stole time from thieves in order to steal a continent. That acquiring Aboriginal land would have been ineffective without a source of labour to work it. That labour came from a tried and tested means, transportation, and the length of transportation sentences played a very, very important part in that. One of the things that my team has done laboriously, working with organisations like the Female Convict Research Centre, is take every single conduct record for each convict and digitize it. We've completed this work for the 13,500 female convicts. We're now working through the male convicts. So each of these records summarizes the reasons why a convict was transported, but then lists every single magistrate's bench offence in summary form on the record. So for the female convicts alone, there are 73,000 magistrate's bench encounters that are summarised in these records. If you count the males, it's well over 400,000 court appearances. And so having digitised all of these, we can now form life courses where we can look at the impact of punishment on an individual, and we know precisely when they spent time in a solitary cell, and we can also link those records to subsequent events, like when they married, had children, and we can now for the first time look at the impact of transportation on life expectancy. This produced, I think, some pretty startling results. So I'll just tell you what the overall number of strokes of the lash administered in Tasmania was. It was over 1,400,000, exclusively to men, at an average of 24 strokes per male convict. The number of days in solitary was about 800,000, so that's in a dark cell on a diet of bread and water. And the solitary confinement exposure for women was twice that of men. They spent 21 days in solitary confinement compared to just 9 for male convicts. And there were nearly 20 million days spent at hard labour for female convicts, washing the colony's laundry and doing other menial tasks, and for men largely on construction projects, especially the roads. Now, we took 5,000 female convicts that we could link to a death record, and we looked at the impact of solitary confinement. About half of that sample never spent time inside a solitary cell, and the other half did. And unfortunately, this bit I can't visualize, but what I can do is tell you the net result of that, which is after taking into account earlier life course circumstances, like the amount of time that a woman had spent as a sex worker before being transported, the number of times they've been prosecuted, and where they have been born, each day in solitary confinement reduced life expectancy by 10 days. So I think it's probably the first study in the world that's been able to do this, because we had such a fantastic data set. Now, the big question is, were there intergenerational implications for that? And as Kate was suggesting earlier, if we can tease these kinds of things out for the descendants of convicts, then we can start to, I think, make an assessment of the impact of colonisation and similar kinds of events on intergenerational quality of life for First Nation Australians. In terms of offending, John Braithwaite is the criminologist who has been most positive in his assessment of the impact of transportation on subsequent offending rates. And one of the things that Braithwaite says is that transportation is an inclusionary system in contrast to the prison. So when you sentence somebody to prison, you literally put a wall between them and the economy. It makes it very, very difficult post-sentence for them to re-engage in a legitimate way of life. Whereas transportation does the opposite. By exploiting a convict for the course of their sentence, it also gave them skills and it gave them connections to the labour market. One of the ways in which John pushes this case is to look at the post-transportation legacy of offending as measured by Court of Session and Supreme Court encounters in Tasmania, of course, the place most impacted in Australia by convict transportation. And by the end of the 19th century, Tasmania has the lowest conviction rate of all colonies for indictable offences. So in other words, if we use the Court of Session and the Supreme Court record, transportation appears to have worked. There's no evidence of an intergenerational legacy. We've tested this by bringing in the lower court records, and we're able to do this by looking at the amazing Tasmanian Police Gazette, which doesn't start until 1865, but lists a very good description of every single prisoner. So it tells you whether they're a former convict, whether they arrived as a free settler, or whether they're born in the colony. and we can look at this record in huge detail. There's enormous variation in what discharged prisoners were prosecuted for over time. We have these records digitized from 1865 to 1924. They're 51,000 discharges. So what we can do with this record is reconstruct the life expectancy or the life course prosecution history for individual convicts. And in some cases, we actually have photographs of them in old age when they were rearrested. So we can do this for individual men, but for women, we can do it for the entire cohort. And this enables us to engage in a little bit of an experiment. We can compare their prosecution history in Britain and Ireland with their prosecution history while under sentence in Van Diemen's Land, with their prosecution sentence when they become free, when at least they've served a sentence to transportation. And we can do this for 13,500 women. When we do this, something quite interesting happens. What we find is that the prosecution rate under sentence is very high. And then there's a rapid drop-off. And we have to control for sort of various other bits and pieces, but even when we do that, then the life course prosecution risk drops immediately that somebody becomes free. Now, what's even more interesting about this is if we split this into indictable and non-indictable offending. So that's the type of offending that you're likely to end up in a court of session or a Supreme Court for, compared to a police court or a magistrate's bench. We can see that the time under sentence, 2/3 of all prosecutions were for breach of the rules and regulations of the convict system. They were essentially for not working hard enough. Most of the rest were for public order offences, low-level things like being drunk and disorderly. And a tiny proportion were for under 10%, were for things that could be civilly prosecuted in a higher court. And so one way of looking at this is that despite the record of prosecution, convicts under sentence were surprisingly law-abiding. When we look at post-sentence reoffending, again, most of it is for non-indictable offences. Braithwaite is right here. Where convicts do turn up in the courts, it's in later life when they're elderly and they're mainly tried for public order offences. And one very good way of illustrating this is that when we look at all of the prosecutions that we could find for female convicts who have been rearrested after they've been released, there's about 1,500 of them. We found that the 75 women who were rearrested more than 10 times were responsible for 34% of all reoffending by former female convicts. So what we have is a small number of persistent offenders who, if you like, are very, very visible in the courts, in a system where most female convicts actually appear to desist from offending if you take the court record at face value. I'm going to very, very quickly illustrate this with the case of Hannah Riles, who was charged 6 times while she was a convict. She arrived when she was age 15, by the way. At age 22, she married another convict called Jeremiah Callahan. Her record then is completely blank, and it's only when you link her up to the police gazettes that you find that after the death of her husband in 1883, she was then prosecuted 5 times for indecency and being idle and disorderly before her death of senile decay and exhaustion in 1899. But critically, she has no children. So when her husband dies, in a system where there is no welfare state, she has no means of support. And this is what we see again and again and again. It's the female convicts without children who are turning up in the court system. So a rapid summary here is that we've got plenty of evidence that Braithwaite is right, and that transportation is doesn't leave a slick of subsequent offending through the courts. And very quickly, in the 2 minutes I've got left, I'm going to describe something else that we've done, which is to look at the children of convicts. enormous numbers of children appear in the Tasmanian Police Gazettes, far more so than do in Victoria and New South Wales. We're not sure why this is the case. It's certainly worth examining further. Our first reaction when we saw this is going to be the children of convicts. This is what you might expect, that they're being their exposure risk to prosecution is much greater than the children of free settlers. We've in the middle of a project linking these children to their parents so that we can test this. At the moment, we have found no evidence whatsoever for increased prosecution amongst the children of convicts. We have found something else that is very interesting, though. Because we have the heights of these children, we can measure advantage and disadvantage in other ways. Since although 80% of your height is, or at least 80%, is the product of your genetic inheritance, the degree to which you will be able to achieve your genetically programmed height is strongly influenced by your early childhood circumstances. So it's disease encounters, the quality of drinking water, etc., etc. So we were able to use these records to explore the growth patterns of children in Tasmania who were arrested and discharged by the courts from 1865 onwards. Now, the risk of provoking the North-South War in Tasmania, one of the things that we found was that it was much better to be born in Hobart than it was to be born in Launceston. That there was a distinct height penalty associated with being born in Launceston. But the other thing which just astounded us was that when we tested to see how much shorter the children of convicts were, we found that they were taller than the children of assisted migrants. We sat down and started thinking about this, well, how can this possibly be true? And then we found that the effect is not statistically significant if you have a convict father, but is much stronger and is statistically significant if you have a convict mother. Now, if we reflect back to Hannah Ryle's case, you'll remember that Hannah Ryle's had no children. One of the tragedies of convict transportation is that the sexual policing of female convicts massively reduced their chances or their fertility. So female convicts had fewer children, much less children than you would expect for an age group with their profile. We now think that this bizarrely conveyed some kind of an advantage because the families where there was a female, former female convict mother were smaller than those where there was no history of offending amongst the mother. The mother had not been transported. And because there were smaller numbers of children, there was more food to go around per head. And in fact, we have other studies which show convincingly that there's a height premium that's very strongly associated with family size. And at that point, Virginia, I'm going to stop.
Thank you greatly for that presentation, Hamish. Although I do have to say, as a short, aging, childless woman, I found it a little depressing. Now, I see we're at 5:12. The session is to end at 5:15. Unless someone immediately throws their hand up with a question, I think I'm just going to take the advice of our Chief Justice, who considers that a lawyer isn't worth their salt if on a Saturday by 5:15 they're not having their first martini. Can I thank or ask you to thank all our speakers again? Thank you very much. And I think that brings this afternoon's session to an end.
Hamish, well done.